So
to see. Yeah.
it looks like it just shows who's speaking at the time. So then if we start speaking, the committee, it should, and then if you were to start speaking,
Which is probably what we want. That's what we want to be broadcast. Actually,
yeah.
who's speaking? Here's Laurie. Let me just invite. Well, yeah. So at the moment, what I can see, there's a bit of a lag. I can see the chamber, and I can see, yeah, because I'm speaking, it's then gone to me. That's probably what we want, isn't it?
Yeah, I think
so. I don't need to share my screen. It can just be as it is at the moment.
Yeah.
It's got quite a big lag. It's got about a minute lag, but that's fine. That's great. I don't know whether from about 10 to
Okay, good morning, everyone. It's 10 o'clock. Looking at my screen, it looks to me as if all the key participants this morning are present. I'm just waiting. Perhaps Mr. Collinson wants to put his camera on, and then I think we've got Mr. Cox has put his camera on. I think we've got everyone then. So I'm not aware of anyone missing. So that's a relief to start with.
Yeah.
Okay. Well, let me say a collective good morning to you. Just a couple of bits of housekeeping before we move on in earnest. I was going to thank all parties involved for the updated inquiry documents. I have seen the plans about the landscape buffer, the farm holding, and the census table. So thank you very much for that. And my thanks for the Section 106 note. That's very helpful, not often done. So that's very much appreciated. I think the only things that I am adrift on in terms of a witness list from the council with the various qualifications and job titles, I don't seem to have that yet. And also whether there's any further changes to the conditions. So I don't know if there's any update in the conditions. Perhaps Mr. Garvey, I'll start with the council on any changes to the conditions.
So not that I'm aware of. On the appearances list, apologies, sir. We'll get that to you in the next hour.
That's okay. That's all right. Yeah.
But I don't know whether Mr. Collinson can weigh in on the conditions points.
They have been agreed. So it's just a matter of sending them through. I'm sure I talked to Mr. Cox earlier on this morning. That's something he was going to be doing.
Okay, that's fine. Is that your understanding as well, Mr. Cox?
It is, sir, yes. So hopefully we can get those across to you in the next couple of hours.
Okay, that's great. Okay, well, my thanks for that. And then I will need to set a date this morning for the signing of the Section 106, but we'll come on to that later. So I think in terms of housekeeping, that's it from me. I'll just start with apart from confirming and thanking you all for the site visit itinerary, so I appreciate that and the details. So, Mr. Garvey, any more housekeeping from the council's perspective?
Just on, so we've sent through our closing submissions to yourself.
I've got it. Thank you. Yeah.
I don't believe there's anything else unless Mr. Collinson weighs in and tells me otherwise.
No, I've got a shaking of the head. So, okay, Professor Phipps, anything? Thank you for your statement this morning. I have got that, so thank you for that. Anything further to add before we proceed in earnest this morning?
No, sir.
Okay, thank you. Mr. Corbett Bircher, anything from the appellant's point of view?
No, sir, nothing from the appellant.
Okay, that's okay, great. Okay, well, it would be helpful to go through the Section 106, and it'd be particularly helpful just to be talked through what's involved in that and explanations. That would be very helpful. And then we'll go on to closings in the order of the council, Rule 6 party and appellant, and then I'll move to close the inquiry. So let's begin then with Section 106. Mr. Corbett Bircher, I don't know if you want to introduce the appellant solicitors.
Yes, sir. So you have Stephanie Gusney from Freeths present. She's the author of the note. Whilst I'm not calling her as a witness, she will lead on the Section 106 discussion and explain, in accordance with the note, all the various components there.
Okay, thank you. That's very helpful. So good morning.
Good morning, sir. glad that the note was helpful. I'm intending effectively to run through that note,
Yeah, that'd
particularly
be very helpful.
for
Yeah.
the benefit of those that may not that a section 106 might be new for them. So
Yeah.
just by way of background for those people, so a section 106 is a legal agreement entered into under section 106 of the Town and Country Planning Act, and it's to mitigate the impact of the development proposal for matters that can't be addressed via planning condition. To be a reason to grant planning permission, those obligations must meet the 3 tests within Regulation 122 of the SIL regulations, being A, necessary to make the development acceptable in planning terms, B, directly related to the development, and C, fairly and reasonably related in scale and kind to the development. The LPA has prepared a SIL compliance statement, and Ms. Barker, who's also on the call, has been acting for the LPA on the negotiation of the section 106. We've agreed between us that I will run through the obligations. However, should you have any questions directed to Ms. Barker, please do direct them to her.
Okay, thank you.
So also, if I'm going into too much detail, please tell me.
No, that's fine. That's fine.
Okay.
Yeah, please carry on.
So in my professional opinion, the section 106 includes a standard set of boilerplate clauses. Boilerplate clauses are the clauses governing how that deed works, and the obligations which the deed secures are included within the schedules to the deed. So firstly, the parties to the document, we've got the landowners of title number WK 484494, and title information has been provided previously. So those are the 2 Catons. Then Richborough Estates Partnership are also a signatory. They're the promoter. They don't have a land interest at the moment, but it's just to acknowledge that they would be bound if they bought the site in the future. Then the other 2 signatories are the councils, the Borough Council and the County Council. So, as noted, the section 106 is entered into pursuant to section 106 of the Town and Country Planning Act. This is to ensure that it runs with the land and would be enforceable against successors in title. So then the deed sets out when various obligations come into force. That's clause 4 of the deed. Clause 5 clarifies that the land bound by the section 106 is that shown on the site plan that is appended to the section 106. The site plan that comprises all of the application site boundary, apart from 2 small areas of adopted highway, which are excluded from the land bound. Those areas are shown in purple on the application land plan. There are various payments that are due on completion of the section 106 for payments of legal fees, and then before commencement, monitoring fees for both councils. The deed needs to be registered as a local land charge so that future purchasers of the land would be aware of its existence and the liability it imposes. As usual, liability between the owners is joint and several to ensure the most efficient enforcement for the councils. Then within clause 10, we've got various usual limits on liability and exemptions from liability. So, for example, when someone sells on the site, they are released from the obligations in the section 106, apart from any prior breaches that they would remain liable for. Plot purchasers are exempted from liability as usual. However, they're not exempted wholeheartedly from the affordable housing provisions, because otherwise that wouldn't work for the affordable housing. We've also got a general clause in there at clause 17 that the various contributions are indexed. The councils have confirmed the applicable indexes that they wanted for each of those contributions, but effectively that's just to ensure that the money that actually gets paid across is it's dealing with inflation. Then, so lastly, on the boilerplate clauses, we've got a future section 73 linking clause, so that if a section 73 consent were to be granted, it would link to this section 106. And then lastly, there's a blue pencil clause in there, as we include in all appeals section 106s, just in case so you consider that any of the obligations don't meet those Reg 122 tests. So those are the boilerplate clauses. Sir, do you have any further questions on those?
No, that's helpful. So yeah, please carry on. Yeah.
So then we get into the schedules. So the section 106 secures across the first and second schedule 40% on-site affordable housing. So the first schedule is at pages 19 to 22 of the draft section 106 documents. At paragraph 1, it's confirming that the affordable housing must be delivered and occupied in accordance with the obligations within the first schedule. Then at paragraph 2, there's a requirement that as part of the future reserve matters application, an affordable housing scheme would need to be submitted to the council. That would need to be approved prior to commencement of development. There is a deemed approval mechanism within the section 106 that if there's no substantive response within 8 weeks, it would be considered to be deemed approved. The scheme would include details of the tenure, mix and location of the affordable housing units to deliver that 40% on-site affordable housing. It comprises 85% affordable rented units. So affordable rented units, those are units that are let at a rent of no more than 80% of local market rent, including service charges. Then the balance of the 15% is either or a mix of discount market units at 30% price, at a 30% discount of market value, and intermediate units, which are where an occupier buys a share of the equity in the property, then leases the remainder, and then they've got an ability to increase their ownership share. So then section 106 requires that affordable housing to be delivered in accordance with that approved scheme, and the section 106 ensures that visually from the outside of the properties, the affordable housing is indistinguishable from the market housing. We've then, to ensure that the affordable housing gets delivered at an appropriate time, there is then a restriction preventing occupation of more than 80% of the market dwellings until 50% of those affordable units have been constructed and made available for occupation. Then we've got a second occupation trigger relating to no more than 80% of the market dwellings until all of those affordable units have been constructed. Then we have a provision that ensuring that the affordable housing can only be used as affordable housing. I will touch on some exemptions shortly, but before doing that, it's kind of the section 106, we've drafted it with the intention to future-proof. So in the event that there is an issue in disposing of the affordable housing to an affordable housing provider, we've got a backup situation whereby we've got this cascade mechanism at paragraph 3. This ensures that the owner of the site they first need to attempt to do a deal with a registered provider, and they've got to use reasonable endeavours to do that within 3 months of commencement of development. If they can't do that after using those reasonable endeavours, they need to make an offer to the council and endeavour to complete a contract with the council for the council to take the transfer of that affordable housing. Then the last stage of the cascade, level 3, is that the units would be amended to all be delivered as discount market sale units. And discount market sale units are a product that don't need to be transferred to an affordable housing provider. Your house builder would be able to sell those directly to the purchasers. So it's negating the need to do a deal with an affordable housing provider, but it's still ensuring that the affordable housing is provided. And here it's all, in all circumstances, is provided on site. Then we've got a usual clause in there just ensuring that the provisions of the section 1 that appropriate rights of access and services are granted to those future buyers of the affordable housing. And then a request that came from the council that ensuring that the occupiers of the affordable rented and immediate housing units, they can't be let other than to applicants waiting for housing and who are either on the council's waiting list or are those nominated by the council in accordance with the nomination agreement from a neighbouring authority's housing waiting list. Then lastly, on the affordable housing, we've got a standard mortgagee in possession clause at paragraph 5.2. That's a mechanism which a future lender of the affordable housing provider would need to follow to seek to keep the units as affordable, but in a format which will enable that affordable housing provider to achieve an appropriate valuation for the affordable housing. It's this balance between keeping units as affordable housing, but ensuring that an affordable housing provider can get the funding to then allow them to fund this site at an appropriate level so that they can go and then reach that money to go and then buy and acquire other sites and provide more affordable housing elsewhere. Then lastly, we've got a usual exemption for protected tenant provisions, because if someone's gone and staircased up to 100% of their ownership, they can't, the requirement to keep that unit as an affordable housing unit needs to be disapplied. So that's included. So is there anything else on the affordable housing that you'd like?
No, that's helpful. Thank you. Yeah. So yes, please carry on.
So then turning to the discount market unit, this is we've just set this out as a separate schedule, but
Yeah.
it forms part of the 40%.
Yes.
Affordable housing, and it's also this, in case this cascade mechanism comes into play, it's perhaps a greater amount of the affordable housing on site would be subject to this second schedule.
Yeah. Yeah.
So the second schedule, that's at pages 23 to 25. Again, we've got a requirement that those discount market units can only be occupied as affordable housing in accordance with the section 106 and a resale covenant scheme, which I'll come on to shortly. I just thought worth flagging again that so these units, they'll be sold at 30% of market value, and yeah, and that's secured in the long term. So at paragraphs 1.2 and 1.7, there's a requirement that the resale covenant scheme, so this is dealing with future sales of the discount market sale, must be approved prior to the advertisement for sale of the discount market units, and it must be complied with for future disposals. So I do here, I put it in my notes, but picks up a cross-reference that just needs to change to the version that we submitted in front of the inquiry, sir. That the reference to paragraph 1.3 within paragraph 1.2 needs to be amended to paragraphs 1.3 to 1.5. That's just to ensure that the cascade mechanism, which I'll go on to shortly for the discount market sale, is appropriately captured and it's consistent. Ms. Barker has confirmed that that's agreed on behalf of the council.
Okay, I'll give her a chance to confirm or otherwise that she's happy in a moment. Yeah.
Thank you. So we've got a cascade mechanism for who gets the chance to get the discount market sale unit. So I've referred to it in my note, we've got 4 different levels. Firstly, qualifying persons who are key workers and or armed service members living in the council's area. Then at level 2, those who have a local connection. 3, qualifying persons who are key workers or armed service members living outside of the council's area. Then level 3, any person. There are relevant timeframes at each level of the cascade where you need to seek to do a deal with those people before you're able to move down to the next level of the cascade. Then at paragraph 1.6, it deals with subsequent disposals. So again, those subsequent disposals must be at the discount market price, so 30% below market value, to a qualifying person and or a key worker or an armed service member. They've got to live in the council's administrative area. And it's got to be in accordance with the resale covenant scheme. However, there is a little bit of flex that it can be that the scope of who it goes to can be expanded by something else being agreed in writing with the council, and that would be following in line with the cascade mechanism which I set out for the first disposal. Then the 30% discount is secured by a restriction being added onto the title. So the land registry can't complete the registration to put it in that new person's name unless they get the council effectively to say this has all been complied with correctly. So that's protection for the council and protection for those purchasers as well. That's everything that I have on the discount market sale provisions, sir. Do you have any questions?
No, that's very helpful. So yeah, please carry on to the open space.
Okay, so the on-site open space, that's dealt with in the 3rd schedule at pages 26 to 27. There's a requirement as part of the reserved matters application for an on-site open space scheme to be submitted. That needs to include details of the laying out, planting, maintenance and management of the on-site open space. The on-site open space are those areas within the site which are shown shaded green on the parameters plan. That parameters plan is attached at Appendix 4 to the draft section 106. The precise location and extent of the open space would be determined via the future reserve matters approval and would have to be in accordance with the applicable SPD. The on-site open space is to include a play area, being one local area for play, together with the inclusion of natural play facilities. Then, to ensure that the open space gets delivered, there's a requirement at paragraph 2 that the owner must implement that scheme as approved and make it available prior for use prior to first occupation of 75% of the dwellings. Then at paragraph 3, we've got a mechanism whereby the council inspect the open space, check it's been done correctly, sort out remedial works. But then, as usual, there is a deemed approval mechanism whereby if the council don't respond or inspect within the agreed timeframes, that it's considered deemed approved. We've then got a requirement at paragraph 4 for that open space then to be maintained by the owner and ensuring that it is used as open space for the enjoyment of the public in perpetuity. I anticipate that a future developer would seek to transfer the on-site open space to a management company. So the section 106 requires submission of a management company scheme prior to first occupation of any dwelling, and that management company would have to be set up before occupation of the first dwelling. Then there's a requirement that future plot purchasers would become members of the management company and have to pay a contribution to its maintenance to ensure that it's appropriately funded. Again, we've got protection at the land registry to ensure it is appropriately funded. And then there's a requirement to transfer that public open space to the management company. So that takes me through all of the non-financial contributions within the section 106. Shall I turn to the financial ones, sir?
Yeah, that's helpful. Yes, thank you.
Okay. So then at the 4th schedule, which is on page 28, there is the requirements to pay the sports and recreation contribution. That is payable in 2 chunks, 50% prior to commencement of development and 50% prior to occupation of more than 50% of the dwellings. This contribution has 8 component parts and totals over £374,000 worth of financial contributions. Those component parts are an up to 24,497 3G pitch contribution, up to £51,195 changing facilities contribution, up to 16,796 gym/fitness contribution, a sports pitches contribution of 27,181. Similarly, a studio contribution of up to £10,467, a swimming contribution of up to £58,378, a youth capital contribution of £105,099.53, and then lastly, the last component part, a youth provision revenue contribution of up to a maximum of £80,801.75. Each contribution has got its own purpose, which is set out within its definition for how those contributions can be used. They are all within the council's to be used within the council's administrative area. apart from for the youth provision capital contribution and youth provision revenue contribution, the purpose is instead towards the funding of those facilities within the Polesworth neighbouring plan area or adjacent ward. Now, the contributions, they are calculated in accordance with the council's sport, recreation and open space SPD, which is appended at Appendix 3 to the Section 106. So the next schedule, at the 5th schedule, are the county contributions, and these make up the most substantial chunk of the financial contributions payable. So this is at page 29 of the Section 106. So we have the education contribution. This is has got a number of different component parts to it, but in total it's up to a maximum of £2,038,959, and that's calculated in accordance with various formulae. That payment is payable in 2 chunks. First, 50% prior to first occupation of any dwelling, and 50% prior to first occupation of 25% of the dwellings. So the first component part of that is the early years contribution. So this is for additional early years provision in the local ward or 10-mile radius to serve the development. Is up to a maximum of £250,657. Because this is an outline application, we set the number of units would be fixed at the reserve matter stage. So we've got a formula that's included in my note on that. Then we've got the primary education contribution, that's up to a maximum of £820,332, and that's for additional primary provision at Warton Nethersole Church of England Primary School. The primary send contribution, that's up to a maximum of £130,033 for additional primary send provision in the local area. Secondary and post-16 contribution of £698,616 towards additional secondary and post-16 provision at the Polesworth School, or provision of a new secondary and post-16 school which serves the secondary and post-16 education needs of the development. And then lastly, for education, we have a secondary and post-16 send contribution up to a maximum of £139,321 for additional primary send provision in the local area. So if you'd like me to go into any more detail as to the formulae to calculate those provisions, please let me know.
That's fine, thank you. Yes, please carry on.
So then we have the bus service contribution. That's a fixed sum of £238,608. That's towards public transport improvements in the vicinity of the development, and that's payable prior to commencement of development. Then we have the pedestrian and cycle improvements contribution, which is for £1,176,000, and that's towards improved cycling, walking and wheeling provision towards Polesworth, taking the route of P12 as identified in the council's LCWIP. And that contribution is payable in 3 tranches. So firstly, 20% prior to commencement of development, 30% prior to occupation of 50% of the dwellings, and 50% prior to occupation of 75% of the dwellings. Then there are 4 further contributions which are all payable prior to first occupation of the development. They are the library contribution, which is formula based again, and a maximum of £2,408 towards the funding of provision, improvement, enhancement and or extension of library facilities at Polesworth Library. Then a public rights of way contribution of a fixed sum this time of £6,303.84 to maintain public rights of way which fall fully or partly within a 1.5 mile radius of the site, and a road safety contribution of formula based again here for £5,500 to promote road safety and specifically to fund training and education for vulnerable road users in the vicinity of the development. And the last financial contribution is a TRO contribution in the fixed sum of £6,000 towards the cost of preparing and making a traffic regulation order for a 30 miles per hour reduction on Church Road. The 6th schedule and 7th schedule are on pages 30 and 31. They are covenants from the respective councils to the landowner. So at the 6th schedule, there's a requirement at paragraph 1 that is obligating to on the council to inspect that on-site open space and to issue the relevant certificates effectively to ensure that that is as smooth a process as possible. At paragraph 2, we've got an acknowledgement that the council agrees that they shall have regard to emerging national and local policy in respect of new tenures of affordable housing when considering any changes to the affordable housing tenure mix, and as part of the approval of that affordable housing scheme that needs to be approved as prior to commencement of development. And then lastly, a requirement at paragraphs 3 to 5 that the council must use the sport and recreation contribution for the purposes set out in the section 106, and if they are not expended or committed within 7 years of the date of receipt, those would be repaid to the person who paid it. Evidence of expenditure can also be requested from the council. At the 7th schedule, a similar repayment mechanism in respect of the county council obligations. Again, that's a 7-year time frame. So that covers the obligations.
Yeah, thank you very much, Ms. Grosney. I'll just check, Ms. Barker, I'll start with you. Are you happy with the wording and all the obligations?
Thank you very much, sir, and thank you, Ms. Gosney, for a very thorough summary of the Section 106 agreement.
Yes, indeed.
Yes, so on behalf of North Warwickshire Borough Council, I am happy with the obligations. It's my professional opinion that they do meet the legal test set down in Regulation 122 of the Civil Regulations 2010. So you asked me to confirm that I was happy with the proposed drafting change put forward by Ms. Gosney in relation to its paragraph 1.3, I think, of the Schedule 2 relating to the discount market units. I can confirm that I am happy with that change. Just one very small point of clarification in relation to the discount market units, and that's just to confirm that I'm sure Ms. Gosney would agree with, that it's 70% of market value, so a 30% discount to market value in relation to those units. That was just one point I wanted to clarify.
Yeah. Okay. Yeah. Right. I haven't got any further comments. I'll just check, Professor Phipps. Anything from the Rule 6 party?
No, sir.
No. Okay. Mr. Collinson, I'll just double check. I think Miss Barker's probably covered it from your point of view, but let me just double check.
Yeah, she's covered everything well and been working very closely on this section 106. It covers all the points within the SIL justification that we've submitted as part of the application, because there were some elements, NHS and police, that didn't meet those tests, unfortunately.
Yeah.
But certainly everything in the terms of the 106 are acceptable.
Okay, thank you, Mr. Carson. That's helpful. Mr. Cox, Mr. Corbett-Bircher, anything to add from your point of view?
No, all happy.
No, sir. Nothing to add from the appellant's perspective.
Okay, in that case then, all it involves then is for me to agree a date with you for the signing and sealing. I normally work on a sort of 2-week sort of basis. Would that be adequate?
I think so. I think so, sir. Yes.
Yeah. Right. I'm conscious that we have got Christmas coming up as well. So it's the 9th today.
I'm sorry. So I'm wondering if
Yeah,
the council are able to do it any quicker. Is there a particular sealing date or?
So from speaking with the county council, my understanding is that they sign on Tuesdays and Thursdays. I think from speaking with Ms. Barker, I think the council would perhaps like to be the last party to sign the document. So that would be that we need to get the document signed by the landowners. I am holding a copy that's already been signed by Richborough. So we will get those documents sent out to the landowners as quickly as possible. But to get that returned, I think it's more realistic that we would be able to get the county to sign next week rather than on Thursday. That feels a bit tight, sir. So county perhaps on the 16th or the 18th, and then I would defer to Ms. Barker about the council's processes.
Thank you, Ms.
Miss
Gosney.
Barker, yeah.
Sorry,
Okay.
sir.
No, go on. Yeah, please. Yeah.
It's my understanding that the borough council's sealing days are Monday and Tuesday. Mr. Collinson, please do correct me if I'm wrong, which would sort of be 2 weeks from today, assuming that the document is to be signed by the landowners, sealed by county before it comes across to the borough council, which is my client's preference.
Okay. So is 2 weeks a reasonable timescale then? So if we said 2 weeks today, and end of the day, close of play on the 23rd. Yeah. Okay. All right. Well, thank you all. So if there's no more in terms of Section 106 agreement, we'll move towards closings then. Okay, right. Okay. So thank you. Can I thank both solicitors for the appellant and the council for their participation this morning. It's up to you if you want to stay on the call or not, but appreciate your help. So thank you both.
Apologies, sir, just to reach across you, Miss Barker, could I trouble you to just come back to me offline with qualifications so I can feed them back to the inspector?
Yes, of course.
Thank
Yes,
you.
Thank you, Mr. Garvey.
I'm going to drop off.
Yeah.
Thank you.
Okay,
Both.
thanks all.
Okay.
Thank you, sir.
Thank you both. Okay, so we'll move towards closings. I think probably if we have a sort of comfort break, perhaps before the appellant's closing, so that might be sort of good timing. So, Mr. Garvey, are you good to go?
I am, sir, and hopefully the other parties Mr. Bertram in particular could give me a nod to let them know that they've received my closing.
Yes, thank you very much, Mr. Gull. We have.
Okay. Well, that being the case, sir, I'm going to jump in now then, sir.
Yeah.
Thank you, sir. So the appellant seeks planning permission for up to 110 dwellings with access, landscaping, sustainable drainage features and associated infrastructure. All matters are reserved save for the primary vehicular access from Church Road. The appeal proposal arises out of the council's non-determination of the appellant's proposal. Despite the council not having determined the application, the council brought the matter to the council's planning committee after the appeal had been lodged to understand what position they would have adopted were they to determine the application. The council's officers recommended that members should have refused the application. The members agreed with this view and provided putative reasons for refusal. These closing submissions follow the main issues that were identified from the case management conference note. Main issue 1. It is common ground that the council have a significant housing shortfall and that the tilted balance within a paragraph 11D Roman numeral 2 of the framework is engaged for the purpose of this appeal. Accordingly, the harms of the proposal must significantly and demonstrably outweigh the benefits. Nevertheless, this context does not give carte blanche for development proposals. The settlement hierarchy remains an appropriate mechanism for identifying settlements and locations where development should be focused. Warton is identified as a Category 4 settlement, which is intended to cater for schemes usually of no more than 10 units per policy LP2. This is clearly not the sort of development intended to cater for large-scale unplanned development such as the appeal proposal, particularly without respective improvements in service provision. The appellant highlights that this is not a cap, which is correct, but clearly it gives an indication of the expected levels of growth, which is clearly out of kilter with the appeal proposal. Indeed, the policy discusses usually providing no more than 10 depending on viability, services and infrastructure deliverability. As discussed below, Warton does not have the services to meet this development proposal. Through the examination into this settlement hierarchy, the examiner was clear that the level of development for any settlement should be commensurate with the level, type, and quality of day-to-day service provision. This is hardly a novel approach for settlement hierarchies, but it underscores why Warton is in an appropriate location for this type of unplanned development. The council's settlement hierarchy has been relatively consistent for a lengthy period. Indeed, the examiner for the North Warwickshire Local Plan 2021 noted that the updated settlement sustainability appraisal remained broadly consistent with the January 2010 settlement sustainability appraisal and that it was a proportionate evidence base. This consistency demonstrates that these settlements have remained broadly consistent in terms of facilities and services and consequently their capacity to accommodate growth. This USSA concluded that Warton had relatively poor service and facilities. Indeed, the document demonstrated that Warton had a decreased score in this respect, being 25 in 2010 and to 17 in 2018. Since this time, Warton has seen a further reduction with the loss of the public house, the Fox and Dogs. It is also noted that smaller villages such as Warton are dependent on larger villages and towns for services, particularly higher education, financial services, employment hubs and or large supermarkets, but neither Polesworth nor Dordon cater for all of these requirements. Moreover, Warton has seen a relatively significant expansion over the last decade. The village had 527 dwellings in 2016 and seen an additional 310 dwellings come forward since then. The addition of the appeal proposal would constitute an 83% increase in the size of Warton since 2016, in the context that there have been no additional services or facilities to accommodate for this growth. The council say that the settlement needs time to absorb this level of growth, in particular with additional services and facilities being provided before additional unplanned development comes forward. Mr. Cox accepted that providing too much growth to any settlement could be harmful in principle. This can be experienced in terms of service and facilities not keeping up with the scale of growth, but also any settlement, particularly smaller villages, will lose any sense of cohesion and or community if they are required to accommodate growth too quickly. There is no science, guidance or case law that assists with judging this inherently fact-specific point. It ultimately calls for a subjective planning judgment. But the council say that given the substantial growth over the last 10 years, Warton requires time to absorb this growth as well as allowing time for service and facilities to improve. Accordingly, the harm to the settlement hierarchy ought to be afforded significant weight. Second main issue. The appellant has supported their case with an LVIA and professional evidence. The appellant has sought to denigrate Mr. Collinson's views on the character and appearance debate on account of his expertise and the lack of a competing LVIA. This criticism is overplayed for the reasons below. Firstly, the council do not have specific landscape expertise, but rather Mr. Collinson has provided his professional view in the context of being accustomed to determining applications upon receipt of technical landscape evidence from an applicant or appellant. Indeed, had he recommended approval to members, undoubtedly there would be strong reliance on such a recommendation. Secondly, the pseudoscience associated with character and appearance matters can often be overstated at planning inquiries. Whilst the issue of landscape can be convoluted and somewhat scientific in the context of EIA development, or where the landscape impacts are experienced far and wide, neither circumstance applies here. It is common ground that we're addressing a localised landscape impact. Respectfully, it is ambitious argument to suggest that Mr. Collinson is incapable of properly expressing a view on such localised impacts. Thirdly, there is no guidance document, law, policy, or otherwise that says character and appearance issues must be addressed in a specific manner. Indeed, not even Glivia 3 purports to provide mandatory principles for addressing such impacts. Thus, there is no prescribed approach that must be adhered to. Mr. Collinson was perfectly capable of advancing his view on such matters. Fourthly, it is not uncommon for a local authority not to produce their own competing LVA in an inquiry, typically relying on the LVI produced by the appellant as the baseline evidence base. And finally, one imagines, sir, that whilst it was undoubtedly helpful for you to have heard the respective parties' positions on this debate, your site visit will ultimately be most informative on this issue. Indeed, given we are addressing localised landscape and visual impacts, one imagines, sir, that you will ultimately be forming your own view on these impacts. Both parties accept that there would be both landscape and visual harm. The debate concerns the extent of harm and the weight and policy conflict associated with this harm. Further, the proposal would be spatially and visually isolated and divorced from the main community of Warton. Indeed, the appeal proposal would constitute an extension which is not in character with the distinctive existing village characteristic of a nucleated settlement and transitional nature of this edge of settlement site. The site would be read as an appendage to the settlement rather than being well integrated into the settlement. This issue would be amplified by the lack of proper connectivity of the site to the settlement through pedestrian accesses, which is discussed below. The council afford this significant issue against the proposal in the planning balance. Next main issue. One of the key issues in this appeal is that Warton has inadequate services, facilities and employment to accommodate this substantial scale of development proposed. There are essentially three issues. The first being their inadequate service and facilities and employment within Warton itself for this quantum development. Secondly, the access from the appeal site into Warton is poor. And thirdly, the access from the appeal site to other settlements is also poor. The consequence of the above is that residents of the proposal will be heavily reliant on the private car and there will not be a genuine choice of transport modes per paragraph 110 of the National Planning Policy Framework. In the context of the tilted balance, and particularly in light of footnote 9 of the NPPF, which draws particular attention to paragraph 110 of the NPPF, this is a significant issue that weighs against the proposal. Facilities within Warton. In the appeal pertaining to Kerlow Close from June 2023, Inspector Smith noted as follows about Warton. They said that while the village does offer a few services and facilities, they are insufficient to cater for the daily living requirements of residents. Although I acknowledge that the presence of additional residents could potentially support and enhance the existing services and facilities, I find that easy access to shops, services and job opportunities would heavily rely on the use of private motor vehicles. That appeal was for 28 dwellings and was also determined in the context of the council being able to demonstrate a 5-year housing land supply. Nevertheless, Inspector Smith's conclusions here about the inadequacy of service and facilities within Warton itself remains true today, irrespective of those other issues. This conclusion engages the principle of administrative consistency, namely that inspectors should provide reasons for departing from other inspector decisions. The appellant was invited at several points to justify what reason they were inviting you, sir, to rely on to depart from Inspector Smith's conclusion. None of them withstood scrutiny. Mr. Cox ultimately accepted in cross-examination that the appellant did not have a reason per se, rather it was simply that they were inviting you to reach a different conclusion on this issue to your colleague. The appellant relied on their mitigation in the form of improved bus provision and the access to Polesworth, but this mitigation will not affect the service and facilities within Warton itself, and thus even if this mitigation was provided, these service and facilities would remain insufficient to cater for the daily living requirements of residents. It was suggested that this was a written representations appeal, and also that the evidence before Inspector Smith was wanting compared to what is before you. The first point is that the Planning Inspectorate's long-standing position is that the different modes of appeal are not superior or inferior to one another. Moreover, the appellant did not actually demonstrate what evidence was before Inspector Smith on this point, save for the lack of a bus timetable. However, in any event, as Mr. Cox rightly acknowledged, understanding what the service and facilities are within a village is not a detailed or forensic point. Indeed, Mr. Cox accepted that the inspector would be well capable of judging the services and facilities from a site visit alone. Thus, irrespective of whether this was a written representations appeal and irrespective of the evidence before Inspector Smith had before them, they would be just as well placed to judge this point as you would be, sir. Indeed, it does not require copious evidence to judge what services and facilities there are in a small village. It is a rather obvious and apparent issue from the ground. Moreover, the development proposal will not provide any additional service and facilities within Warton itself. There'll be a financial contribution to the school, nor have there been any change in the services. As a chance, it should say change, sorry, sir. That's paragraph 33. The word chance should be changed, apologies. Nor have there been any change in the service in Warton since this appeal. Finally, the appellant has also sought to argue that there's been a new national planning policy framework introduced since the Curlow Close appeal. Again, this was a non-point, given that the Curlow Close appeal was determined in the context of the 2021 NPPF, which had paragraph 105, which is identical to paragraph 110 of the current framework. In fact, there's only been more emphasis on paragraph 110 of the NPPF in the current iteration national policy, given it is now explicitly referenced within footnote 9 associated with the tilted balance. The facilities within the village are the recreation ground, Holy Trinity Church, the office pub, Warton Village Hall, Warton Store and Post Office, Warton Club, and Warton Nethersole Primary School and Nursery. The employment provision for new residents would therefore be minimal. These services and facilities are naturally limited and reflect that this is a Category 4 village, which should not accommodate substantial growth. There is no reason, therefore, to depart from Inspector Smith's conclusions, and the principle of administrative consistency ought to be adhered to. In terms of access into Warton itself, there are 3 proposed pedestrian accesses into the site. There is a proposed pedestrian access to the recreation ground, albeit there is no pedestrian route, either formal or informal, across the recreation ground that ties into the appeal site. One would essentially have to traverse a grassy area from the appeal site to access the settlement, and thus it is not a proper pedestrian access. There is a proposed pedestrian access near the junction between Church Road and Norton Road. However, the appellant readily accepted during the round table that it's unlikely that individuals would walk back into the village from this access. And the primary vehicular access from Church Road provides a pedestrian and cycle access. Whilst traffic calming measures are proposed along Church Road, the council maintain that walking along this road into Warton would be an unattractive route. Whilst the route is direct, there is limited surveillance across it. There was a previous reliance on access from Red Mile Way by the appellant, but the appellant has subsequently removed any reliance on this as a pedestrian route. Accordingly, the council suggests that there is poor access from the site to Warton itself, but even if it was considered that there is a direct and legible route into Warton from the appeal site, that does not escape the fact that Warton itself does not have the services, facilities and employment to accommodate this quantum of growth in any event. And in terms of access from Warton to elsewhere, the appellant relies on services, facilities and employment from other settlements, most particularly Polesworth. Further, the appellant proposes improvements to the route along Warton Road, Stipers Hill into Polesworth, arguing that this means that the service and facilities within Polesworth would be accessible. However, even with these improvements, it is unlikely that many people would use this route into Polesworth. The appellant has focused on the distances into Polesworth, but distance is only one aspect of walking routes. The planning for walking document says, with emphasis, and I'll take that as read if you consent, sir.
Yeah, that's fine. Thank you.
Thank you, sir. At paragraph 47, even with the proposed improvements towards Polesworth, the route would have virtually no surveillance. Further, the route is not flat, as the name Stipers Hill might suggest, with the route being described by Professor Phipps as very undulating. Thus, even with improvements, it is unlikely that residents would walk such a route to Polesworth, particularly bearing in mind the route back in reverse. The council do acknowledge that the improvement is a benefit, but one that does not attract much weight, given it will not be relied upon by many residents. The NPPF discusses genuine choice. This reflects that the different modes of transport have to be realistic and offer some likelihood to individuals. Indeed, being literal, for most people there is always a choice in how one travels, whatever the distance. Foot travel is always theoretically possible, but where the route is lengthy, unattractive, lacking surveillance, and thus presenting safety risks to some, and or has poor topography or gradients, it becomes less likely people will genuinely seize the choice. The council say that this is the case here. As regards bus service, the bus stops relied upon by the appellant are 680 metres away from the site. The appellant acknowledges that sites should ideally be within 400 metres of development proposals. Indeed, the planning for walking document says as follows on this, and it says the power of a destination determines how far people will walk to it. For bus stops in residential areas, 400 metres has traditionally been regarded as a cut-off point, and in town centres, 200 metres. Thus, given the distance to the stop and then the additional journey on bus, the council say again that this will not be an attractive choice and thus not be genuine for most residents of the scheme. Further, council say that the bus provision itself is insufficient, albeit acknowledges the limited improvement the proposal provides. Further, even with access to Polesworth, this is no supermarket, the co-op store is a small store, nor many other facilities, service, and employment. Thus, even with this added access, the proposal would remain in an unsustainable location. The consequence of the development proposal is that residents will not have a genuine choice of transport modes and instead will largely have to rely on the private motor car. This is a matter that significantly weighs against the proposal. The next main issue, happily there is broad common ground in this issue. The proposal would result in the permanent loss of 5.6 hectares of best and most versatile agricultural land. The appellant and council both afford this limited weight against the proposal in their respective planning balances. The appellant argues that there is no development plan policy conflict associated with this loss. Both policies, LP1 and LP16 of the local plan, provide protection to the natural environment. There was some discussion about the objectives of the plan and supporting text. The appellant was correct to discount supporting text as giving rise to policy conflict. However, the policies themselves address the natural environment. The natural environment clearly encapsulates and embraces best and most versatile agricultural land, as is clear from the fact that paragraph 187 of the NPPF is relevant to the natural environment and it specifically addresses BMV. The appellant's argument that the absence of any specific reference to agricultural land within these policies does not assist. The reference to the natural environment is sufficiently broad that it encompasses agricultural land. Furthermore, the appellant's argument that there was a deliberate intention not to reference agricultural land within the local plan and to defer to the NPPF on this issue is entirely unsubstantiated. There was no evidence at all to support such a contention. Development management policies are not uncommonly written broadly to address a number of different types of development, situations, and scenarios. There is no requirement that they specify every type of issue that falls under the umbrella of the natural environment. Indeed, Mr. Cox did ultimately accept that the issue of BMV was covered as part of the natural environment, and thus these policies did require consideration of this issue. 5-year housing land supply. In Hallam Land Management, which is an authority which we hopefully has made its way into the inquiry documents, sir. Certainly that it was sent through to the planning inspector. Yeah. Thank you, sir. The Court of Appeal acknowledged that the extent of the housing shortfall was a relevant consideration and said that the weight to the benefits of new housing development in an area where a shortfall in housing land supply has arisen is likely to depend on factors such as the broad magnitude of the shortfall, how long it is likely to persist, what the local planning authority is doing to reduce it, and how much of it the development will meet. On either party's case, the difference in 5-year housing land supply makes no difference to their respective planning balances. Indeed, on either case, it is acknowledged that the council have a significant housing shortfall. You heard detailed evidence on various sites concerning their deliverability. It is a matter for you, sir, whether you determine the exact figure advanced by either party or record the broad difference as a broad magnitude of the shortfall. Legally, either option is permissible. But on either case, the contribution the proposal would make is 0.1 years supply. The council maintain that this remains a small and insignificant contribution. The appellant may say that the council's 5-year housing land supply is sufficiently poor that it warrants large-scale development being proposed within settlements such as Warton. The council do not shy away from their difficulties with housing delivery, but the solution is not for large-scale unplanned development in settlements without the appropriate services, facilities and employment to accommodate and support these new residents. Rather, a strategic solution is what the council require. Indeed, the development proposal will only make a small contribution towards the council's 5-year supply. The council will remain with a serious housing shortfall, even were an additional 110 dwellings to be accounted for. Policy LP1. This policy is multifaceted and deals with a number of points. The council say that there was conflict with the policy on the basis of the tilted balance points against the proposal, and there was also conflict with various bullet points within the policy. LP14. This requires that development should look to conserve and enhance and where appropriate restore landscape character. The word conserve means to protect from harm or destruction. Plainly, a proposal that causes harm is inconsistent with the policy objective of protecting from harm. The appellant has pursued a convoluted and difficult to follow argument on this point. When this was tested in cross-examination, Mr. Cox ultimately conceded that there was policy conflict on this. There was an unfortunate and transparent attempt in re-examination to invite Mr. Cox to row back on this concession. The law on this point is abundantly straightforward. One reads a policy and a development plan according to the words within it. There was no competing definition of the word conserve advanced by the appellant, nor could there be. Thus, the word means to protect from harm, meaning a proposal that causes harm fails to conserve. There was a suggestion that one reads the policy as a whole, but that does not escape the basic interpretation point that the policy requires a protection from harm, and given there is harm, there is no such protection. The appellant sought to argue that the NPPF does not impose such a standard. The NPPF requires that there is recognition of the intrinsic character and beauty of the countryside. One recognises this intrinsic value by providing some protection to it. Further, Section 15 of the NPPF is entitled Conserving and Enhancing the Natural Environment, which is clearly consistent with the development plan policies. But even if the NPPF does not provide the same level of protection in terms of conserving landscapes, so what? There is no case law that says one distorts the natural and ordinary language of policies in a statutory development plan so that it can be interpreted in a way that is aligned with national policy. Ultimately, Mr. Cox was right to accept conflict with this policy. Policy LP 30, this policy deals with many aspects that will be relevant to reserve matters, but not exclusively so. Indeed, the policy requires that development should reflect the existing pattern of its setting. The council rely on conflict with parts A, B, and F of the policy. Mr. Cox rightly did not argue that the policy could not apply, given that this was an outline scheme. Rather, he accepted that if the sensitivity of the site is such that it gives rise to issues at the design stage that cannot be resolved, then there would be conflict. Neighbourhood Plan Policy PNP3, this proposal says that the description that the development will not be supported where it is of poor design that has an adverse impact on the character of the area. The council say that there would be harm with the initial part of the policy and also criterions A, B, D, I, and J. And Neighbourhood Plan Policy PNP4, Mr. Cox again accepted conflict with this policy, which remained unaltered by the end of his evidence. I didn't address in this list policy LP2 because I've dealt with that earlier in the settlement hierarchy section.
Okay, yeah, thank you.
Thank you, sir. The council say overall that there is conflict with the development plan as a whole. Further, whilst the council acknowledged the significant benefits of the proposal and the significant housing shortfall it faces, that does not justify allowing such a significant scale of development within a village that has already seen substantial growth in recent years and does not have the facilities and services to accommodate further substantial growth. Accordingly, the harms do significantly and demonstrably outweigh the benefits, meaning that the tilted balance does not point in favour of granting permission. Accordingly, there were no material considerations that justify granting planning permission contrary to the development plan. Accordingly, the council respectfully invite you, sir, to dismiss the appeal. So, unless I can assist further, those are my closing submissions.
Thank you, Mr. Garvey. Professor Phipps, on behalf of the Royal Six Party, can I ask you to invite you to read out your closing submissions now?
Yes, sir. I don't think I'll take quite as long.
No, well, as you wish. The opportunity is yours.
Thank you, sir. Sir, I want to set out clearly why the proposed development is fundamentally at odds with the role and capacity of Warton as a small rural village, and why the scale before you today can't be justified in planning, social, or infrastructure terms. The issue of proportion lies at the heart of the appeal. Warton's a designated Category 4 settlement because it is a small rural village with a very limited service base. The designation is not symbolic. It reflects real constraints, modest facilities, restricted transport, and a rural landscape that cannot accommodate continuous expansion without losing its essential character. To understand the disproportionality, I want to look at what has already happened. When I moved here in 2016, the village comprised of around 500 homes. It now exceeds 800. This growth, an increase of around 60% in less than a decade, is exceptional for a settlement of this scale. Most villages evolve incrementally, organically, with careful phasing that allows time for services, infrastructure, and community cohesion to adapt. Warton has not had that opportunity. The local plan anticipated that Category 4 settlements might accommodate small windfall developments, typically around 10 units at any one time. So 10 units isn't an arbitrary number. It reflects what a village with limited services can reasonably absorb without being overwhelmed. It is also the quantum at which development remains physically and socially connected to the existing settlement. The proposal in this case is orders of magnitude beyond that threshold. In the context of a location intended for small-scale organic growth, this scheme represents a disproportionate step change, one that reshapes the village rather than complements it. When a settlement like ours has a modest baseline, even a seemingly medium-sized scheme can transform its structure, identity, and service demands. Here, the scale is not merely large, it's village-defining. It is also important to recognise the cumulative picture. Warton has absorbed multiple major developments in a short period. The result is a form of expansion that no longer feels integrated into the existing village, but instead forms a perimeter of new estates. Residents have described this outward spread feels like the creation of a gated periphery, with the historic village becoming the inside and the new housing forming an exterior belt that neither contributes to nor connects with the original centre. This sense of detachment is itself a symptom of disproportionate growth. Proportionality is not simply about numbers, it concerns relationship. A proposal must be proportionate to the role of the settlement, to its transport infrastructure, to its service capacity, to the safety and functioning of its roads, and to the social resilience of its community. This scheme fails on those fronts. When I first moved to Warton 9 years ago, the village supported 3 public houses, one of them serving food and had a dining room, a social club, and a shop/post office. Today, only one of those pubs remain. During this time, the bus service has not scaled its timings to meet the changing needs of the village. This matters in a discussion of proportionality because we're often told that new housing brings economic vitality. In Warton, the opposite has occurred. We've gained housing at speed and scale, but we've lost facilities. The logic that increasing population automatically strengthens local services simply has not played out here. Services have contracted even as now housing numbers have surged. It is a legitimate question to ask whether Warton can sustain or benefit from further significant development. Based on recent lived experience, there is no evidence that additional dwellings will reverse the decline in services or enhance the village's economic fabric. Proportionality also demands an honest assessment of accessibility. Warton sits at the far edge of the borough. It's just kilometres from Staffordshire and Tamworth to the west, and only 100 metres or so from Leicestershire to the east. Around us in these counties, hundreds of houses are being built. Indeed, 10,000 are planned within 5 kilometres at Norton Heath. Yet none of these schemes contribute to our housing supply, and they don't contribute to the service base of Warton or North Warwickshire. Our lived reality is shaped not by North Warwickshire's settlement structure, but by a patchwork of neighbouring authorities whose developments place pressure on our roads and services, but provide us with none in return. Public transport provision is limited. Buses run only every 2 hours, do not directly serve essential destinations such as the GP surgery or our administrative centre, Atherstone, and do not operate at times suitable for commuting or evening access. Rail commuting is effectively absent. These constraints make car dependency unavoidable. When development is added at a scale that assumes infrastructure capable of supporting it, but that infrastructure does not exist, the result is not sustainable growth, but cumulative vulnerability. I fully support the provision of social and affordable housing, but fairness must apply to both the people who already live in the village and to those who would move here. Placing social housing in a location where residents cannot reach medical care without multiple buses, where children cannot safely walk to school, and where employment opportunities require car ownership creates structural inequity. Sustainable communities are not created by placing people in homes without ensuring that they can live well within them. This proposal does not provide that foundation. Warton has historically been a cohesive community with a shared social life and strong local engagement. Rapid development has strained that character. Residents describe rising antisocial behaviour, greater anonymity, and a sense that the village is becoming a dormitory settlement rather than a functioning rural community. Again, these concerns stem from disproportionate growth. The community has not been given time to adjust or to integrate newcomers into village life. Development at the scale proposed risks accelerating this fragmentation. Proportion is not a minor or procedural point. It is the principle that ensures development supports rather than overwhelms a settlement. It is the principle that ensures growth is distributed fairly across the borough rather than concentrated in its most vulnerable corner. And it is the principle that allows rural communities to evolve while retaining their identity, service base, and social fabric. Warton has already exceeded what can reasonably be considered proportionate growth. The proposal before you is not a continuation of organic development. It is a further escalation that Village cannot absorb. It would exacerbate isolation, increase car dependency, place further strain on declining services, and deepen existing social pressures. For these reasons, and with respect for the inquiry's process, I submit that the appeal should be dismissed.
Thank you, Professor Phipps. I suggest we have a short break now. Is 10 minutes sufficient, Mr. Corbett-Bircher?
Yes, sir, I think so. I've just issued a PDF to Mr. Cox, and he will send that across
Thank
to
you.
Mr. Legg very shortly. And so hopefully that will get to you before the 10 minutes is up.
Hopefully, yes. And I think John Legg is on the call, so he's normally very efficient. So
I haven't got it yet.
No. Okay.
I'll hang on for it. No problem.
I think it's just gone to Mr. Cox, so it'd be a couple of more minutes, Mr. Legg. But
all right.
No worries.
Okay.
As soon as I get it, I'll forward it on to you.
Thank you very much, John. Appreciate your considerable help. Let's adjourn for 10 minutes then, and we'll resume just after, well, let's say 11:26, as we're all in front of computers and got electronic clocks. Let's say 11:26, we'll resume with closings from the appellant. Can I suggest procedurally you all mute microphones and cameras in the intervening? Okay, thank you. Okay, I'm just looking round at my screen, and I think all the key participants are still with us, so that's positive. Thank you, Mr. Corbett-Bercher. I've now had your closings. So if I could invite you to read through it, thank you.
Just checking, sir, before Melanie Venn does that. Hopefully the appearances from the council have reached you now. If they're not, they should be with you any moment.
All right. Well, thank you very much for organising that, Mr. Garvey. Appreciate that. I'll just double check before we close that I've got them. So thank you. I appreciate your help with that. So Mr. Corbett-Bercher.
So thank you very much. So I'll go to page 1. You can see our contents set up there in 5 parts. And then paragraph 1.1. The appellant has promoted the appeal scheme with a single consistent message. There is a major need for residential development in North Warwickshire right now, and the appeal site is the right location to address it. 110 homes, including 44 affordable homes, will address a serious shortfall in respect of both market and affordable housing, directly in line with the expectations of national planning policy. The dwellings will be located within easily accessible distance to the village's services and facilities, the primary school, shop, post office, public house, village hall, social club and nursery, using Church Road or via access through the recreation ground immediately adjacent. The development is also within walking and cycling distance of the larger settlement of Polesworth with its wider collection of services. The appeal scheme is in fact uniquely well placed to ensure the improvement of walking and cycling connections between Warton and Polesworth. It will provide financial contributions to the pedestrian and cycleway along a route which has been expressly identified and recommended by the local highways authority. It will also provide contributions to increase the bus services from 8 to 10 a day and provide additional stops on the route as far as Ventura Park in Tamworth. The appeal site is well screened by existing vegetation to the north, south and west, and to the east the development is immediately adjacent to the recent cornfields development which was completed in 2022. The appellant's cross-disciplinary team have designed the site boundary and the development parameters to ensure that the dwellings will be located at an appropriate distance from existing development and the adjacent road, set within significant public open space and additional landscaping. And the appeal scheme will effectively round off the settlement in this location, generating a strong boundary to the wider countryside. In summary, the appeal scheme is a good one. It accords with both the development plan considered as a whole and national policy. However, even if it were to be identified that there is a conflict with the development plan considered as a whole, the national policy still directs clearly towards the grant of permission through the presumption in favour of sustainable development, using the simple framework of NPPF 11D2. That is to say, the adverse effects do not significantly and demonstrably outweigh the benefits. The appellant's position is the benefits are cumulatively substantial, and the adverse effects, including many potential development plan conflict, no more than limited. The council's planning witness, Mr. Collinson, accepted that even if the adverse effects were considered significant and the cumulative weight to the benefits corrected to significant, then permission should still be granted. In summary, the planning balance and overall section 38.6 BCPA decision clearly lies in favour of a grant of permission in this case. I turn then to national planning policy. The government's national planning policy on residential development now has a particular clarity and force, and this must situate all consideration of the development plan and the council's putative reasons for refusal. Since the July 2024 election, ministers have repeatedly emphasised their determination to see the delivery of 1.5 million homes within the Parliament's 5 years by mid-2029. And to achieve this, the government wishes to see a sharp increase in grants of permission by all local planning authorities and across a wide range of sites. That policy imperative is reflected in the current NPPF, notably paragraph 61 and 78, and also in the written ministerial statements of the 30th of July 2024 and the 12th of December 2024. The mission is to reverse an acute and entrenched housing crisis across England by addressing it with the urgency that this demands. And the current Secretary of State expressed complete continuity with the WMSs in two statements delivered in October 2025. And my emphasis below is added. He emphasises that he wishes to put the key to a decent home into the hands of every single family that needs it. And further, in the next quote, that 1.5 million homes and communities, they're seeking to build those homes and communities that working people desperately want and need. And that 1.5 million homes policy objective is therefore it's not simply an aspiration. It's a very real practical objective that requires a significant increase in grants permission now across a very wide range of locations, including unallocated sites. The presumption in favour of sustainable development plays a vital role in this, as the WMS makes clear. If there is a housing shortfall below 5 years, then the presumption must have, I quote, real teeth. Any authority that cannot demonstrate a 5-year supply of housing is out of step with the government's aims. And regrettably, the council in this case has not merely undershot the 5-year supply target, but is presiding over a devastatingly low housing land supply figure. Delivery has effectively collapsed. There is no prospect of addressing housing needs through the adopted strategy, and the presumption must therefore be applied to support the grant of permission in the effective vacuum left by the absence of strategic housing delivery. I turn then to the development plan. Whilst the development plan is the starting point for the purposes of Section 38(6) of the 2004 Act, this is a case where it is very much not the end point. The appellants and the council's dispute centres on the 6 policies named in the putative reasons for refusal: LP1, LP14, LP16, LP30, and the neighbourhood plan policies at PMP3 and PMP4. There is agreement there is no conflict with any other policy. The Rule 6 party have not themselves identified any specific conflict with any other policy. It is agreed that the most important policies for the determination are out of date, most notably policy LP2, which sits at the heart of main issue 2. The interpretation of several development plan policies has been disputed between the appellants and the council. Whether the appeal proposal would breach policy LP2's reference to usually on sites of no more than 10 units at any one time, and I'll address that later at main issue 1, section 5 below. Whether limited harm can give rise to a conflict with LP16's LP14's single term conserve. Whether the loss of best and most versatile agricultural land would give rise to conflict with policy LP1's single reference to the natural environment. Again, I'll deal with those in the respective sections below. These focus disputes, as to interpretation, do not and cannot obscure the overall position in the context of the presumption. Even if conflict were identified with any of the above policies, the extent of actual harm that will arise is very much at the lower end of the scale, limited harm to be attributed limited weight, and accordingly the presumption continues to direct towards the grant of permission as the decisive material consideration in this case. So I turn then to what I describe as main issue 1 and related planning matters, and I begin with housing land supply and some preliminary remarks on its relationship with main issue 1. Main issue 1, the effect of the proposed development on the settlement hierarchy of the borough, is closely intertwined with, or perhaps bookended, by 2 allied issues. 1, the council's housing land supply, and 2, the likely course of the local plan review. Because the local plan was adopted recently in 2021, the council's housing land supply is heavily dependent upon the deliverability of a relatively concentrated number of allocations, that's 17 in total. And as we shall explore in section 5, the council saw a fundamental change of position in early 2025, when the funding for the A5 improvements was withdrawn by government. There are also evidently a range of other deliverability challenges on other sites. The result is a housing land supply figure which is not simply a very low number, but also has a spatial and geographical impact. The key sites in the larger settlements have either stalled or are subject to major delays. There is no prospect of other strategic sites coming forward in those settlements to replace them. It is therefore instructive to look closely at each of the sites relied upon by the council as deliverable, mindful of the national policy tests, particularly the need for clear evidence. mindful of the national policy test. There's a bit of repetition there. Need for clear evidence. This robust approach to deliverability is in line with the overall national policy imperative. Government plainly wishes this test to be applied with real rigour to ensure the achievement of the 1.5 million homes objective. The parties' positions on housing land supply were initially set out within the Statement of Common Ground schedule and explored during the roundtable session. And Mr. Pycroft's oral submissions were grounded in his detailed proof of evidence. In terms of requirement and shortfall, the appellant has used the stepped housing requirement, and this reflects the current PPG, as well as the local plans monitoring framework referencing Appendix B and the inspector's report. The council explained in the round table that they had explored the higher annual requirement due to the strategy becoming out of date and the absence of a specific policy text reference to the stepped housing requirement. The first submission, that is out of date, merely underscores the wider problem covered in main issue 1, and that second submission is not formally a basis to reject the stepped housing requirement. In any event, adopting the council's figure, that annual requirement approach, would simply see the housing land supply figure fall even lower. So as to the calculation of the scale of shortfall, once the step requirement is used, the appellant's 544 should be adopted in preference to the council's 439. The council used a COVID period adjustment, which was only applied to the requirement side of the HDT calculation. And the council is required to record actual completions in those 2 years. A 5-year housing land supply cannot be reduced by completions which did not actually happen. The council's suggestion that they have always done it that way is not a cogent justification. So I turn then to supply. The primary dispute in respect to supply is concerned the deliverability of 11 sites amounting to 1,393 units. The appellant's position, applying the straightforward MPPF definition and PPG 68007 and many appeal decisions, is that the council has not provided the requisite clear evidence. In closing, we shall not recite each of the appeal decisions relied upon by Mr. Pycroft. It will be clear from that extensive list that the council's approach is clearly out of step with what government has long required since the 2018 change to the MPPF. The 2 appeal references are, however, noteworthy. They demonstrate how the council's approach is in fact something of a throwback to approaches which were robustly dismissed at the end of the last decade. First, this case is unusual as a contemporary 2025 case, and the council has sought to make its arguments without any proof of evidence, or indeed any supporting documentary evidence. In the Woolpit appeal, Inspector Stevens noted how that LPA, in the earliest days of the new MPPF test, had not even come close to discharging the burden to provide the clear evidence that is needed for it to be able to rely on these sites, and that perfectly describes the current position. The council has not sought to document the up-to-date position on a single site. There has been no attempt to provide any actual documentary evidence to confirm, for the purposes of 68007, current planning status, firm progress towards the submission of application, for example, emphasise a written agreement between the local planning authority and the site developer, and clear, relevant information about site viability, ownership constraints, or infrastructure provision. And second, Mr. Pycroft's appendices set out a range of documentary evidence that was not enough to persuade inspectors as to deliverability. See notably, for example, the Braintree pro formas in his EP1. These were not considered sufficient by the Secretary of State. The evidence in this case falls well short of even that standard. The council has been strikingly resistant of scrutiny of the housing land supply position, including interim efforts to have the issue removed from what the council described as forensic examination, we say detailed consideration, altogether. Given the close relationship with main issue 1, the principal controversial issues are not confined solely to identifying the overall supply figure. The more fundamental point is that the larger allocations of the plan are simply not deliverable, and that underscores the need for grants of permission on other sites in different locations, such as the appeal site. I begin then with allocation H2, site A1. This is a very large site without planning permission. The council did not provide any clear evidence of firm progress being made towards the submission of a planning application, or clear evidence of firm progress with site assessment work. And in the roundtable session, for the first time, The council referred to a submitted outline planning application, which had only been validated the previous day. The central difficulty remains that the council have not provided any documentary evidence in support of this, and the onus was firmly on them to do so. In any event, as an outline permission for a large site, a correct approach to the PPG and the clear evidence test would entail far more than simply referring to the submission of an application. As with all of the sites relied upon by the council, there is no written agreement between the council and the developer to confirm their anticipated start and build-out rates. The council's statement that delivery on homes will begin in less than 2.5 years is therefore not supported by any clear evidence. The Lichfield start-to-finish work is a very well-established reference point in this field. It identified that on average, sites of this site will take 6.2 years from the validation of first application to the completion of the first dwelling. And so in summary, in the absence of clear evidence, this site should not be included in the deliverable supply and 250 dwellings should be removed. I turn then to site A2. This is allocation H4, land to the east of Polesworth and Dordon. This is an even larger site than H2 and again does not have planning permission. There has also been no planning application and there is no evidence as to when one will eventually be submitted. The council have not provided any clear evidence of firm progress being made towards the submission of a planning application or clear evidence of firm progress with site assessment work. There is no written agreement between the council and the developer which confirms their anticipated start and build-out rates. In the roundtable session, the council referred to the low numbers projected, that's 50 in each of the final 2 years, and the identity of the developer. However, it's readily apparent from all the circumstances that this site, the largest allocated in the plan, is significantly delayed by the A5 issues. There is absolutely no documentary evidence before the appeal that a single home will be delivered from this site before the end of the 5-year period. And once again, the Lichfield start-to-finish work is instructive. The council considered that delivery on homes will begin in less than 2.5 years, while Lichfield's found that on average sites of this site, 1,500 to 1,999 dwellings, would take 6.6 years from the validation of first application to the completion of the first dwelling. So again, in the absence of clear evidence, this site should not be included in the divorce plan. 100 dwellings should be removed. I turn then to allocation H9. This large site does not have planning permission, and whilst an outline application for 400 dwellings was made in March 2018, it was refused in June 2023. Again, a reference I could read for each one of these: no clear evidence of firm progress towards submission of application, or clear evidence in respect to site assessment work, and no written agreement. In the roundtable session, the council noted that planning permission had been refused for the access by Nuneaton Borough Council, but that there were further issues in respect to local quarrying. So the overall impression is of a situation that's becoming more, not less complicated. This is a situation where documentary evidence should have been provided and was not, leaving the only conclusion that the site is not deliverable. Again, the council considers that delivery on the homes will begin in less than 2.5 years. However, the Lichfield start-to-finish work finds that on average sites of this size will take 6 years from the validation of first application to the completion of the first dwelling. So again, we say in the absence of clear evidence, this site should not be included in deliverable supply and 100 dwellings should be removed. At Michael Drayton Middle School, the site had full planning permission from a medical centre, which has now been completed. There is an outline planning permission granted in April 2025, but there have been no applications for reserved matters. Again, same paragraph applies, no clear evidence of firm progress towards the submission of the reserved matters application, or in respect of firm progress with site assessment work and no written agreement. In the roundtable session, reference was made loosely to a development partner being on board and future reserved matters applications, but once again, nothing has been documented or presented to the inquiry. This is wholly insufficient, even for a site of this smaller scale. So we say again, absence of clear evidence, not including deliverable supply, 20 dwellings should be removed. We turn then to allocation H10, land south of Coleshill Road, Annesley Common. The site does not have planning permission. A full planning application for 62 dwellings has been made, and the appellant has included that within the housing land supply. Again, no clear evidence of firm progress towards submission of applications for the remainder of the site, or clear evidence of firm progress with site assessment work, and no written agreement between the council and developer, which confirms the anticipated start and build-out rates. In the roundtable session, the council referred to progress in identifying an access, but once again, it's impossible to consider this clear evidence in the absence of any supporting documentary evidence, and especially in respect to the actual delivery timescale. Again, we say no clear evidence, shouldn't be included in the deliverable supply, 88 dwellings should be removed. Allocation H11, former school redevelopment site, Attleborough Lane, Vicarage. The site does not have planning permission. A full planning application for 48 dwellings was made 2.5 years ago in June 2023. However, that is subject to unresolved objections from statutory consultees, including on highways, ecology and drainage, and the council did not provide any evidence that these issues had been resolved. In the roundtable session, the council offered little more than anecdotal observations that work was ready to begin. For any reliance on this, the council had to provide actual clear evidence, and they provided no documentary evidence at all. So again, we say no clear evidence, and the remainder of the site therefore should not be included in the deliverable supply. 48 dwellings should be removed. Allocation H7, land at Church Farm, Basleyanza. The site does not have planning permission. There's an outline planning application for 46 dwellings made 2.5 years ago in June 2023, and a resolution to grant was made in January 2025. However, the Section 106 agreement has not been signed, and therefore the decision notice has not been issued. Even if outline permission is granted, planning permission is granted, it will remain as a Category B site. And the council has not provided any clear evidence of found progress being made towards the submission of the reserved matters application, or clear evidence of found progress with site assessment work. And again, no written agreement between the council and the developer confirming anticipated start and build-out dates. At the roundtable session, the council offered no further update on the conclusion of the Section 106 or any delivery timescale, and indeed again presented no documentary evidence at all. So again, we say no clear evidence, not deliverable supply, and 47 dwellings should be removed. Allocation H5, land west of Raby's Lane. This is a very large site, but only has outline planning permission granted relatively recently in July 2025. The application was submitted as long ago as 2018 and took 6 years to reach approval, and that averts the complexity going forward. Applications for reserve matters have not been made, and there are 36 conditions. Again, we say no clear evidence of firm progress being made, or clear evidence of firm progress with site assessment work, and no written agreement. Nevertheless, the council considers that delivery on homes will begin in less than 6 months' time. No evidence has been provided to justify the lead-in time and the build-out rate. In the roundtable session, the council could refer only to meetings with the developers, Persimmon Homes and Charles Church, earlier this year. Both are, of course, share the same parent company, Persimmon plc, with implications for the exact rates of delivery in parallel on adjacent sites. The council's officer explained candidly that when the house builder representative claimed that they would deliver 180 homes per annum, officers were, I quote, very surprised. And they were right to be on a site of this scale. And officers should have cut their protections to zero in the absence of any evidence. Once again, the council's approach here is the antithesis of clear evidence. And so in the absence of clear evidence, this site should not be included in the deliverable supply, and 300 dwellings should be removed. I turn then to allocation H1, land at Old Holly Lane, Athelston. The first phase of this site has planning permission for 123 dwellings and under construction, and that is already included in the 5-year housing land supply. The site includes second and third phases. The second phase of the site has detailed consent for 250 dwellings, granted on the 18th of September 2025, which the appellant has included in the 5-year housing land supply. The council has not provided any clear evidence being made towards the submission of a reserve matters application or clear evidence of firm progress with site assessment work for subsequent phases. There is no written agreement between the council and the developer which confirms their anticipated start and build-out dates. And in the roundtable session, the council's officer could say no more than they were expecting it to come forward, but exactly when I can't say. So in the absence of clear evidence, the remainder of the site should not be included in the deliverable supply, and 249 dwellings should be removed. At Britannia Works, the site has extant planning permission for 70 dwellings, which was approved approximately 5.5 years ago. No works have taken place on site since the site clearance and surveying works were undertaken in November 2022. The site has remained derelict since that time, and development has stalled. The existing building still remains on site, although it has partially collapsed. In the roundtable session, the council referred to a board report with a resolution to approve, but no decision has yet been issued. Whilst references have been made to the extra care nature of the facility, to Homes England support, and to the involvement of the Canal and Rivers Trust, none of this has been documented. And thus, for the final time, there is an obvious practical consequence to the absence of any documentary evidence. None of the council's assurances in the roundtable session have been supported by anything that will allow proper verification of their claims as to delivery. And so for all these reasons, the site fails to meet the definition of deliverable, and 70 dwellings should be removed from the council's supply. And the final site, land opposite 104 Warton Road. The site has permission for 71 dwellings, 51 have been completed, which leaves 20 dwellings rather than 21 dwellings, a difference of one dwelling, which should be removed from the supply. Windfall. Mr. Pycroft has explained through his proof of evidence why the additional 120 windfall units is not justified in line with NPPF 75. Paragraph 75 of the NPPF requires that where a windfall allowance is to be made, there should be compelling evidence that windfall sites will provide a reliable source of supply. Any allowance should be realistic, having regard to the strategic housing land supply assessment, historic windfall rate, delivery rates, and expected future trends. Now, the council have included a windfall allowance of 60 dwellings per annum in years 4 and 5, which equates to 120 dwellings in the 5-year period. However, this is in addition to the dwellings on known windfall sites, i.e. those with planning permission already included in the housing land supply. The historic windfall delivery rate in North Warwickshire has been 29 dwellings per annum. This would mean 145 dwellings in the 5-year supply period, yet the council already includes 168 dwellings on known small windfall sites in the 5-year housing land supply. And so the addition of a further windfall allowance of 120 dwellings would mean past trends were exceeded. If the council's case is that larger windfall sites may come forward in addition to small windfall sites, it should be noted that some of the known large windfall sites are already included in the council's trajectory in years 4 and 5. In the roundtable session, Mr. Pycroft directed to a number of sites included in the council's Excel table. That's CD 1061. For example, at rows 42, 127 and 150. So if the council is suggesting that large windfall sites are included in the allowance, then there is double counting with known large sites in these years, and therefore the 120 dwelling windfall allowance should be removed. So in summary, the council's own claims supply figure is already very low, but the true figure is even lower still once the NPPF test is applied correctly. As Mr. Pycroft's Table 1.1 explains, summarising the deductions immediately above at his paragraph 116, the council can only demonstrate 848 dwellings against a requirement plus 20% buffer of 5,154 dwellings, and that represents a massive shortfall of 4,306 dwellings, largely owing to the non-delivery of sites allocated in the local plan. And in that context, it's clear that officers have not yet properly understood the scale of the problem in their consideration of the planning balance. This is one of the lowest housing land supply figures to be considered at appeal this year. Their insistence on according a weight that is lower than the highest level of substantial weight, or purported basis, here are Mr. Collins's words, that the contribution is not numerically significant, and that it would not materially improve the 5-year housing land supply, is not a credible position. It is seriously out of step with what government policy requires. And we'll return to this in section 11. So main issue 1, settlement strategy, the effect of the proposed development on the settlement hierarchy of the borough. The spatial strategy. The local plan spatial strategy has failed, and to a very significant degree, such that all references to harm to that strategy or to effects on the settlement hierarchy are somewhat illusory. Put simply, the local plan and policy LP2 specifically are seriously out of date, such that the weight that can be accorded to any conflict with that policy LP2 must be substantially reduced. The inspector's report and the withdrawal of the A5 funding. Mr. Cox's proof of evidence has set out the full factual background to the adoption of the local plan and what went wrong. The inset map at his figure 1, relationship between A5 improvements and local plan allocations, which is drawn from CD 10.12, the written statement from Warwickshire County Council, illustrates the interrelationship between the A5 funding agreement upgrades and the allocations. The A5 is a major strategic route, and without improvements, the strategic locations cannot grow, and I'm citing there the local plan. As the local plan explains at 1221, it is difficult to see how the current road will be able to cater for such growth without substantial investment. Investment will unlock a number of development sites. The availability of government funding for A5 improvements was arguably the critical justification which allowed the local plan to proceed. As the inspector noted at his paragraph 289, a plan must represent a deliverable strategy. As submitted, delivery of a significant element of the development proposed via the plan is reliant on upgrades to the A5, around which allocations are primarily focused. And the inspector's report 289, 285 recorded the then understanding of the significant sums of money that would be available to front load and advance the necessary works listed in Mr. Cox's table 2, and he set up the timetable there and his table 2 in his proof. Following the local plan's adoption, the projected costs trebled, therefore removing the necessary cost-benefit ratio such that the funding had to be withdrawn in its entirety, and it's therefore now apparent that government will be even less likely or able to make this larger sum available. The issues and options document, published last month in November 2025, records and emphasises the clear need for a different strategy focused on timely delivery over the short term. I emphasise paragraph 6.1. The growth options behind the adopted local plan need to be reassessed. And in 6.4, it said that it could be argued that this will inevitably mean the focus is on those options that are most likely to enable and encourage delivery over the short term. And perhaps I should read that earlier section. That's because the housing need and delivery is a priority along with the government's growth agenda. All but one of the 6 growth options listed refers to likely delays to delivery, with options 1 to 3 all noting that the timeline for external funding sources does not necessarily correspond to the need to deliver homes in a timely manner. And option 5 further noting that new settlements would be equally delayed. Development can take many years to start and to build momentum as well as deliver the number of homes required. I turn also to affordable housing shortfalls. The overall housing shortfall has been matched by a corresponding desperate shortfall of affordable housing. The council has been delivering well short of the required number of affordable dwellings per annum for a number of years, and the shortfall against the more recent headland-derived lower target is already 419 affordable homes. Annual rates of delivery in the past 2 years are lower than the total number of homes to be provided through the appeal development. And I'll come back to affordable housing in section 11. So turning to the appeal proposal's accordance with policy LP2, the appeal development would accord with all key elements of policy LP2 of the local plan, of which the core test can be divided broadly into 3 paragraphs with 2 or 3 main subtests, and I've denoted these here by square brackets and underlining. So turning to LP2 paragraph 1, the first sentence of LP2 is not a test in its own right. It is a general description of an overarching objective. That's how I set it out there. The specific tests are the sentences that follow. It should also be noted that the hierarchy does not specify any specific figures or caps for the individual settlements. There is no specific figure identified for Warton within LP2. So turning to square bracket 1, day-to-day service provision, level, type and quality. The development's 110 new homes are commensurate with the level, type and quality of the day-to-day provision which is currently available in Warton. As Mr. Cox has explained, and as the site visit will confirm, Warton has a primary school and a nursery, a church, 4 community halls and clubs, 1 pub, a convenience store, a post office within that convenience store, a frequent bus service, and leisure and open space facilities. All of these are documented in the Settlement Sustainability Assessment for 2025, which has assessed Warton as the third most sustainable Category 3 settlement, with Category 3 tier replacing the former Category 4 tier. So residents of Warton can A, educate their children at the primary school, B, buy daily provisions at the shop, C, post and receive packages and undertake everyday banking at the post office, and D, socialise and congregate at the pub and the community facilities and the recreation ground. And these are all day-to-day activities readily available within walking distance of the appeals site. As Mr. Parker has also observed in his proof of evidence, in 2025, these day-to-day activities can be supplemented by extensive online delivery options using sustainable transport modes, electrical vehicles, and the rise of digital remote working supported by fast broadband. And I've provided the reference to his proof. As Professor Phipps himself noted, there is a high number of people working remotely in the settlement already, so this form of employment is clearly possible. The Council have made much of the very briefly recent findings in two earlier appeal decisions, most notably the single statement by Inspector Smith in the Land off Curlew Close decision at paragraph 8, where she said, furthermore, while the village does offer a few services and facilities, they are insufficient to cater for the daily living requirements of residents. And the Fox and Dogs appeal, that's back in 2020, was even brief on this point, simply referring at paragraph 9 to a limited range of services and facilities. The Council maintains that the principle of consistency requires an explanation for why a different conclusion should be reached. The Council accept, however, that this is not, in their own terms, a forensic question, but one on which a judgment can be reached from the site visit. The short answer is that the level, type, and quality of the services listed above are all entirely sufficient and commensurate with the appeal development size. That is especially when one fully considers both the range of the services and the nature of the provision, as well as the changes in how goods are acquired and employment is carried out in late 2025. The earlier inspectors did not enumerate the services and facilities. However, the appellant has now done so, and in some detail, through the evidence of Mr. Cox and Mr. Parker. Moreover, it's very notable that the Council considered that the services were entirely adequate for Warton to be considered a sustainable location in each of the three 2019 decisions to grant planning permission in Warton, noting in particular the presence of the primary school and the shop and post office, and the local plan even allocated a site of the same size through allocation 816. And so I'll come back to those points about Curlew Close in response to the Council's closing submissions at the very end. The ability, this is point 2 then, the ability of the services to absorb development. The settlement services do have the ability to absorb this level of development, and this is no longer contested by the Council. Mr. Collinson accepted that he was wrong to record that the development would cause services to exceed capacity. The appeal proposal is making substantial financial contributions in respect of education, sport and recreation and transport, and there is no sign that any of the existing services will not operate effectively. And there's also no objection from any statutory consultee in this respect. Moreover, as Mr. Collinson accepted, the residents' additional expenditure would support the shop and post office and the pub, and this is self-evident from the location of the access and direction of pedestrian movement along Church Road. For example, trips to the shop en route to or back from the school. This is also entirely consistent with NPPF paragraph 83. So I turn then to paragraph 2 and the test of enhance or maintain the vitality of rural communities. The appeal proposal will enhance and maintain the vitality of Warton, especially given the economic points just noted. Mr. Collinson accepted this. Proportionate in scale to the relevant settlement. The appeal development is proportionate in scale to the settlement, whether measured as a population increase of 264 individuals, added to the projected current number, that's the current dwellings and the consented dwellings of 2185, or as 110 households added to 830 households. The Council's attempts to compare historic population increases do not amount to a conflict with the express terms of policy LP2. The policy does not, and it never could, require proportionality to be measured by reference to what the population or household figure was historically in 2016, let alone 2001 and 2011. The only correct way to assess the policy is by reference to the current. That also accords with the government's growth agenda and the clear message from government that they do not simply wish to carry forward historic under-provision. I turn then to paragraph 3, the own merits component. The Category 4 test begins with a clear acknowledgement that every development must be assessed on its own merits. As the Council itself acknowledges, the policy is not prescriptive and it depends on service and infrastructure availability. So we turn then to usually on sites of no more than 10 units. The wording usually on sites of no more than 10 units at any one time expressly acknowledges that the figure can be exceeded. 10 units is not an absolute cap. And as Mr. Cox observes, a limit of no more than 10 units makes little sense now in the context of the major housing land supply shortfall and can no longer be afforded any real weight. The three qualifiers, viability, services and infrastructure availability, have been largely addressed above. The development is viable, and this test is plainly not determined in this case. As to services and infrastructure availability, the development is not only supporting the services, but it's also delivering new infrastructure through the contributions. And I'm emphasising there the pedestrian cycleway between Warton and Polsworth. So in summary, on accordance with policy LP2, the proposal is therefore in accordance with policy LP2 and the settlement hierarchy considered as a whole. If it were to be concluded that there is a conflict, for example, with a number usually on sites of no more than 10 units, so with that number 10, that does not amount to a conflict with the policy as a whole. Even if it did amount to a conflict, that is not a conflict that can be accorded anything more than the lowest levels of weight in the overall planning balance due to the dateness of the policy. I turn then to dateness and weight. Policy LP2 is agreed to be out of date. Using the well-established Bloor-Holmes definition of that term, it has been overtaken by things that have happened since it was adopted, either on the ground or in some change in national policy. And in this case, the position's both. The allocations which are central to the spatial strategy have been severely delayed, and national policy has moved on from the point of the 2024 general election and the subsequent NPPF. It is plainly not government's intention that settlements of Warton scale should be limited to 10 units at a time, whilst all of the major strategic sites are delayed and all other options, for example, reserve sites, are equally accepted to be undeliverable. Policy LP2 is inconsistent with the NPPF, and most notably, paragraphs 61 and 78. And under main issue 3, I'll cover that in section 8 below, we shall explore how the development accords with NPPF 110 and 115. Accordingly, it cannot be said that any consistency with those policies, so that's the policies, consistency with those policies, increases the weight to be accorded policy LP2. So in summary on main issue 1, in summary, there will be no effect on the settlement hierarchy and certainly no harmful effect, nor will there be any harm to the development strategy in the Council's terms. The Council position on main issue 1 fails to understand and grapple with the failure to the strategy and the natural consequence that development must therefore come forward on other sites, such as the appeals site. The Council's attempts to present the status of the settlement in the village as somehow resolved by the 2020 local plan examination simply fails to take on board the scale of what has changed since 12th of December 2024 and indeed beforehand at the general election. Before moving on to the other main issues, it is necessary briefly to consider the Council's case on the local plan review and the prospect of a new strategy being adopted. The Council have what can only be described as an ambition to submit a local plan with a new strategic approach ahead of December 2026, proceeding straight to Regulation 19. That timescale is not remotely realistic. The issues and options document is very high level, and it demonstrates the Council are a long way from resolving matters through any new local plan. The Council have not published a single detailed evidence document other than the solitary Settlement Sustainability Assessment 2025 update. There is no sustainability appraisal, even scoping. There's no strategic transport assessment, and there's no published outcome from the call for sites, as these sites have not even been analysed. The appellant's position is that there is no realistic prospect of submission of any new plan submission next year, with major consequences for the date of adoption. Eventual submission would appear unlikely for several years yet, further delaying that prospective adoption. In the Issues and Options document, officers expressly acknowledge that the Council will have to look at a more dispersed strategy if they wish to deliver homes in a timely fashion. They will therefore not have an adopted local plan with the requisite new allocations for a considerable period of time. So in short, this is not a case in which any reliance can be placed on a future plan to address the pressing needs that exist now. And this renders further release of land through decision taking essential. Timely delivery, that's the Council's words, mean grants of permission for schemes of the present scale right now. There is simply no alternative to granting homes, save through the application and appeal process. And this must occur in other deliverable locations, including Category 4 settlements with the higher sustainability, such as Warton, especially given its proximity to Polesworth. So I turn then to main issues 2, 3, and 4, starting with main issue 2, character and appearance. The three matters covered in main issue 2 have been explored within the roundtable session and will be examined further on the site visit. In the section below, we underscore various points from the roundtable and the LVA assessment work, and we then revisit the question of development plan compliance with policies LP14, LP30, PMP3, and PMP4. So, surrounding landscape. The appellant's LVA has carefully set out the respective landscape effects and visual effects from 14 agreed viewpoints as well as from close-range views. The appellant's LVA is in accordance with GLIVIA, that's agreed, in the Statement of Common Ground, and it was the subject of prior discussion with the Council in respect to representative viewpoints and accurate visual representations, like photomontages. The local landscape character assessment was identified so the LCA was identified in the North Warwickshire Borough Council Landscape Character Assessment 2010, i.e. the No Man's Heath to Warton Lowlands Landscape Character Area. And the development is agreed to be local in extent and impact, not affecting the overall character of the LCA. Landscape effects. As Mr. Bullock explained in the roundtable session, he had had particular regard to the published landscape management guidelines for the LCA, including the sections on pressures for change and key issues, and landscape management strategies. I quote there, that conserve and strengthen the rural character and disperse nuclear settlement pattern of this agricultural landscape. The site, this is his findings, it has medium landscape value, and it does not lie within a designated landscape. It has a medium susceptibility to change, and overall it has a medium sensitivity as undesignated countryside with some distinctive characteristics and few landscape detractors. The site is also notable for its thick surrounding hedgerow of native species, but otherwise is an open agricultural field. So in this context, the appeal development will be an open scheme with extensive public open space and green infrastructure. The illustrative landscape master plan has closely followed the LCA's published management guidelines. Development will also step back from the boundary to reduce discernibility. This will allow the existing hedgerows to be bolstered and for the provision of new native tree, hedgerow and scrub planting, as well as enhanced grassland and landscape attenuations, and no trees will be removed. So for all these reasons, the landscape effects identified in the LVA are accurate and they are robust. In particular, at year 15, effects on the appeal site will be moderate/minor adverse, and effects on the host landscape character area will be minor and adverse. Visual effects. The visual effects have also been carefully tabulated within the LVA and the topic-specific Statement of Common Ground. As the LVA Section 5 explains, there are limited close-range views into the site, largely from Warton Road and Church Road, from the recreation ground, and from the adjacent cornfields development. The development would therefore be experienced against the wider village. The wider landform significantly restricts any longer range views into the site from any publicly accessible locations. There is only limited scope to see a part of the site from the open countryside to the east/southeast on elevated landform, that's Warton Road, around Warton on the Hill, and also along the approach to the village from the south along the roadway at Barn End Road. However, once again, the site will be seen in the context of the wider village. At year 15, the vast majority of the identified viewpoints are therefore imperceptible or minor adverse, with only 2 which are moderate minor adverse. And those are viewpoints 13 and 14 as the footnote sets out. This is not substantially altered by the Council's request to move viewpoint 11, given the overall representative nature of the viewpoints. I'm referring there to Mr. Collinson's remarks about viewpoint 11. The Council's evidence. The Council's own officer's report accepted that the overall effects on landscape character would be limited and that the visual harm would be relatively localised in extent. And the main statement of common ground confirmed that both landscape and visual effects would be local in extent and impact. Mr. Collinson's proof of evidence then largely echoed the report's overall findings. But Mr. Collinson declined to agree with the appellant's overall landscape effects and visual effects in the topic-specific landscape character and appearance SOCG. However, his explanation for this in the round table was merely that he was not qualified as a landscape professional and therefore unable to agree with the findings in the LVA. That does not amount to a robust and careful, considered response to the LVA conclusions, and it's certainly not a strong platform for a different view. Mr. Collinson had also earlier placed emphasis on residential receptors. He'd emphasised the local communities that live adjacent, but he accepted in cross-examination there's no right to a view, and accordingly no weight can be placed on such harms. So for all these reasons, the appellant's evidence should be preferred, such that the harm is all very much at the limited level, giving rise to no conflict with either LP14 or PMP4, or indeed LP30 and PMP3, that should say, nor with MPPF 187. The Council's case on this matter, I'm turning now to settlement morphology. The Council's case on this matter has been hard to follow, undoubtedly because there's no real merit in its objection. The Council's specific objections initially centred on the depth of development in an area which was said to have a distinct linear form. Yet, as Mr. Bullock has observed, new development is already situated in this location at the southern and southwestern edge of Warton. The Council's various submissions on settlement morphology and alleged impacts on Warton's historic nucleated layout appear to have been largely based on historic map regression and aerial photographs. However, as Mr. Bullock has observed, the photographs and maps actually reveal that the appealed development's growth is entirely in character with what has preceded it. The appeal development has been proposed in a part of the village which has a long history of built development along Church Road and around the church, with recent developments, Red Mile Way / cornfields, as well as more latter-day development and period properties. There are also large dwellings in large plots, with an obvious residential curtilage along Church Road running westwards from Maypole Way. The village has grown to the southeast and the southwest, so that the church and its burial grounds and the public open space are no longer peripheral to the main route through the village at Maypole Way. So the Council's linear/nuclear distinction is unfounded. Whilst the historic core of the village had a cluster formation along the route of Osprey Road and Maypole Road, development from the 1950s onwards followed outwards, with the growth of the village along these routes extending south, southwest and west towards the appeal site. Mr. Collinson's 2021 and 2025 aerial photographs show subsequent growth since 2005 with the provision of homes at Red Mile Way and the streets thereof. And the development will be fully in line with the morphology of how the village has already evolved from its nucleated core. Moreover, as can be experienced by visiting Warton, the contemporary growth of the village is not a detraction, but the core of the village still experienced along Maypole Drive and in particular Osprey Road. This pattern of growth is already one which is established and long-standing to the southern half of the village, i.e. on land south of the junction of Osprey Maypole Road and Church Road. So in summary, the village has grown to the southwest and the west for a number of decades, effectively wrapping around the church and the recreation ground. There is no historic morphology which requires a particular degree of protection, and accordingly none that will be harmed. Turning then to spatial integration with the existing development, there are two parts to the council's objection. A concern that the line of development on the eastern side is not sufficiently proximate to the cornfields, notwithstanding the aforementioned concerns about visual effects. And secondly, the absence of a footpath between the internal indicative routes on the eastern side of the appeal development and the Hammerhead junction at the end of Red Mile Way. Addressing the first point, the development has been expressly designed to provide setbacks on each side, which allow for an appropriate distance from the round and any surrounding development. I should say road, I'm sorry. On the eastern edge, this enables both a publicly accessible open space and a buffer, which ensures that the appeal dwellings will be an appropriate distance from the adjacent development. And it also allows for the incorporation of SUDS elements and landscaping in the southern eastern corner. The spatial relationship between the appeal development and cornfields development and specific Red Mile Way is therefore entirely appropriate. Mr. Collinson's criticisms of the absence of access from Red Mile Way was misguided in the context of the application history, but was pursued with less vigour as the evidence progressed. There is a full vehicular and pedestrian access onto Church Road, and the origins of this have been explained by Mr. Cox. There was earlier express opposition to access via Red Mile Way, both by the residents and the LHA, and accordingly this was changed to Church Road. This change was entirely appropriate, as the Church Road main access and the recreation ground offer the quickest and most efficient route to the centre of the village. See here the rebuttals of Mr. Cox and Mr. Parker, and as Mr. Cox and Mr. Bullock have further explained, the placement of open space on the eastern side allows for connecting open space. The public open space at this location has been designed to mirror that provided opposite in terms of quantum, alongside the attenuation pond, which will be enhanced through native planting and habitat creation. There will be public access through the surface pathways, and the surface and the space between them then would be open to walk over. To the west, the development will also allow for a pleasant walking route to the public right-of-way, affording access to the wider open countryside beyond the village. There is therefore no specific harm at all from the absence of an additional access or footpath in this location. The appeal development dwellings and those on Red Mile will be located at an appropriate distance from each other, with the exact form of intervening landscaping and open space all capable of being addressed at the reserved matter stage. So I turn then to development plan compliance, beginning with policy LP14 and the question of conserving landscape character. The Council has suggested that there will be a conflict with LP14 on the basis that even limited development, I should say that's probably, that development would not conserve the landscape character because it would lead to a level of harm, however small. That submission does not appear in any of the Council's evidence before that point, most notably in the officer's report and Mr. Collinson's own proof of evidence. Mr. Collinson appeared not to recognise it as reflecting regular practice in cross-examination. This submission appears to have been based on the rather different case of Wadhurst Parish Council against the Secretary of State, 2025, which considers separate statutory tests under the Crow Act 2000, that's section 85A1, which is specific to national landscapes, aka areas of outstanding natural beauty. And I set out 85A1 below. It refers in exercising or performing any functions in relation to or so as to affect land in an area of outstanding natural beauty. A relevant authority must seek to further the purpose of conserving and enhancing the natural beauty of the area of outstanding natural beauty. At Wadhurst, paragraphs 39 and 40, Mr. Justice Mould referred to his earlier judgment in New Forest National Park Authority and Secretary of State, again from 2025, in respect to the similar wording in section 11A of the National Parks and Access to the Countryside. And we can see there the provisions of this part of the act shall have effect for the purpose of conserving and enhancing the natural beauty, wildlife and cultural heritage of national parks. And in that earlier case, this is conveyed at 39 and 40 of the Wadhurst judgment, which you have, he notes there, I drew attention to the ordinary English meaning of the word conserve as being to preserve intact or to maintain an existing state, and to prevent something of natural or environmental importance from being damaged or destroyed. This approach had been guided by a separate judgment on the different term preserve in the context of Section 72 of the Planning, Listed Buildings and Conservation Areas Act in an earlier case, a much older case, South Lakeland District Council and Secretary of State from 1992. At Wadhurst, paragraph 41, Mr. Justice Mould cited his earlier finding in New Forest that the approach of leaving unharmed applied to the statutory purpose of conserving the natural beauty, wildlife and cultural heritage of a national park. And I set out the quotes there, emphasising obviously where he says, in determining application for planning permission in relation to land within an area of a national park, it's necessary for the decision maker to consider whether the proposed development will leave unharmed the natural beauty, wildlife and cultural heritage of the national park in its existing state. And the further quote below, in such a case, the decision maker will have properly sought to further the statutory purpose, I emphasise, of conserving and enhancing the natural beauty, wildlife and cultural heritage of the national park by satisfying themselves that to grant planning permission for the proposed development will leave the specified characteristics of the national park unharmed. So in Wadhurst, this was accepted to be the correct approach to the specific statutory duty in section 85A1 in relation to designated areas of outstanding natural beauty. So it will be immediately apparent that the statutory wording is different to that which appears in LP 14, which merely states within landscape character areas as defined by the LCA 2010, in this case, or successor documents, developments should look to conserve, enhance and where appropriate, restore landscape character, as well as promote a resilient functional landscape able to adapt to climate change. So the LP 14 text simply requires that development should look to conserve landscape character. The duty is not expressed in the same mandatory terms as any statutory landscape or heritage duty. The target is general landscape character, not the natural beauty of a statutorily protected landscape. And sections A and B within LP 14 then explain how this should be done through landscape proposals and new landscape features. And the Council have not raised any objection in respect of A or B. It's also instructive to look at the national context. The title to Chapter 15 of the NPPF, Conserving and Enhancing the Natural Environment, applies only NPP 187B, which requires mere recognition of the intrinsic character and beauty of the countryside. So in short, when addressing the non-statutory, non-designated landscape, the position is far simpler than the Council is now trying to suggest. One has to have regard to the whole of the landscape effects. A proposal does not automatically give rise to conflict simply because any harm has been identified. And the appellant, through the LVA, has identified how any perceived harm that is seen to arise as a result of the change in land use from agriculture to residential development and immediate open space can be balanced by the opportunity to create landscape enhancements in accordance with the Landscape Character Assessment 2010, by the same document which is referred to within the text of LP 14 itself. The appeal proposal provides a real opportunity to create a new sense of place for the new and existing community, as well as mitigate the existing settlement edge. And the illustrative landscape master plan and the eventual reserve matters stage of the detailed landscape design will follow the published management guidelines and their recommendations in respect of retaining, protecting and enhancing the existing landscape fabric, as well as the provision of new landscape planting in terms of types, structure and species. And these measures have been integrated within the landscape, green infrastructure and habitat creation measures proposed by the appellant within the public open space. This also includes the retention and enhancement of the existing field hedgerows and the hedgeline trees. The detailed landscape design at the reserve matter stage could also include the replanting of lost and previously extracted hedgerows where appropriate. So in summary, the LCA's Landscape Character Area 1 qualities will be conserved and enhanced, such that there will be accordance with LP14 overall. And even if the council were right that conserve means that the occurrence of any harm would give rise to conflict, it's clear that the resulting harm would still be very much at the lower end and incapable of mounting to significant demonstrable harm in the overall planning balance as part of the presumption in favour of sustainable development under MPPF 11D2. So I turn then to LP30, built development. Mr. Collins identified that the council's dispute was confined to policy LP30's subparagraph A, B and F only. And the council therefore evidently accepts that the appeal proposal would accord with all of the other subparagraphs, or that they're not applicable to the present case. The appellant's position, through the evidence of Mr. Bullock and Mr. Cox in their previous evidence, and that the roundtable session, is the appeal proposal would accord with subparagraphs A, B and F. So LP30A, the development will harmonise well with the immediate setting and the wider surroundings. Development is concentrated where it is most appropriate in environmental terms to do so, with circa 2 hectares of the overall 6.37 hectares site proposed for forms of open space use. This open space will include natural and semi-natural landscapes, habitat creation, and new landscaping to conserve and enhance typical landscape features of the host landscape character area. The new dwellings will be of 2 stories in height, with some pepper potting of up to 2.5 storey at nodal points within the scheme. And the scheme is proposed at a similar density to the existing settlement pattern neighbouring the site. The scheme would realise new development within the southern half of the village, which is reflective of the recent development prevailing since the late 1990s. And it would still ensure the function of the nucleated village core and the linear development pattern to the north along Austria Road. The proposed scheme would provide a significant contribution to local green infrastructure in the form of increased tree cover, habitats and public access as a feature of the proposals, again reflecting the landscape management guidelines as prescribed within the landscape character assessment. So in summary, the site is of sufficient scale that it can integrate this within the scheme green infrastructure of retained and bolstered landscape fabric, as well as new landscaping and habitat creation. L30B, make use of and enhance views into and out of the site, both in and outside the site. The appeal proposal would accord with this subparagraph. The provision of extensive swathes of public open space around the scheme and setting the new dwellings within the core of the site will enable views out of the site to its immediate setting or to the open countryside along the southern edge beyond Warton Road. The opportunity for these views has been balanced with the retention and the enhancement of the existing field range, hedgerows and hedgeline trees, as well as new planting within the public open space. And the green infrastructure of the scheme would also create an attractive setting for the new homes and would reflect the distinct local character of the host landscape character area. So in these views, the landscape proposals create appropriate foreground open space and appropriate roadside planting, such that the development will sit very well within its local context, being seen in conjunction with other built developments and receiving similar treatments in landscape terms to that which already exists in the locality. LP30F, ensure that the buildings and spaces connect with and maintain access to the surrounding area and with the wider built water and natural environment. Again, the appeal proposal would accord with this subparagraph. The proposed scheme marries the proposed public open space, and that along the southeastern edge of the scheme near Red Mile Way and Chilwell Close, to offset the effect of the new scheme. Similarly, the proposals would step back from Warton Road with a swathe of green infrastructure and public open space. There will be formal public open space through the scheme, as well as semi-natural and natural green space with green corridor routes running through the scheme for pedestrian and cycle-friendly environment, or cycle-friendly movements, and linkages to the wider urban area and open countryside beyond the boundary of the site, both on the eastern side via Church Road in the recreation grounds and through the access at the western edge. So I turn then to policy PMP3, which is entitled Sustainable Design and Construction. Mr. Collinson identified conflict with only the following subparagraphs of PMP3, A, B, D, I, and J. And the short answer to all of these points is that they are essentially reserved matters, which will be determined and addressed in the layout, in the detailed stage. Given the scale of the site, there is no reason to conclude there is any conflict now. Given Mr. Bullock and Mr. Cox have addressed these comprehensively in writing, again, they've addressed these comprehensively in writing and at the roundtable session. So PMP3A, referring to promoting and reinforcing local distinctiveness. And the ingredients there saying, demonstrating the appropriate account has been taken of existing good quality examples of street layouts, blocks and plots, building forms, styles, materials, detailing in the vernacular of the settlement. So this part of PMP3 is clearly a question for reserved matters. In terms of local distinctiveness, the illustrative landscape master plan shows how the published landscape management guidelines can be incorporated for the host landscape character area. The detailed landscape design at reserved matter stage would specify native species of local importance, reflecting the specifics of planting, or I should say the species of planting found locally in hedgerows, tree belts, and trees with plantings supplied by local provenance where available. The site is of sufficient scale that it can integrate the scheme within green infrastructure of retained and bolstered land fabric, as well as new landscaping and habitat creation. The provision of public open space to the eastern and the southern edge would marry in with the existing public open space, complementing and enhancing placemaking along this edge of the village. The proposal would not lead to any physical or visual coalescence, as demonstrated through the LVA study and the accurate visual representations. Through the enclosure of the site by landform along its northern and western edge, the scheme will be contained, and it would reinforce the scattlement settlement pattern noted beyond Warton within the No Man's Heath to Warton Lowlands Landscape Character Area 1. So PMP3B says it's designed in such a way as to make a positive use of local landform, trees, hedgerows, and other vegetation, and for larger proposals that had suitable regard to landscape setting and the settlement pattern. And many of the points raised immediately above apply to this subparagraph too. The proposed scheme would optimise the retention of the existing landscape features and, where practicable, bolster the existing landscape fabric, including existing field hedge lines and trees, which enclose the site's boundaries for visual mitigation, as well as the ecological amenity and habitat retention, as well as contribute to the structure of the landscape for the integration of the proposed scheme within. Despite the site being situated within landform gently rising to its western and northern edge, the design of the site has clearly sought to set new built form well within the northern and western site areas to offset from the higher landform of the site area. PMP3I refers to, it includes measures that seek to improve pedestrian facilities and linkages in the parish and beyond to encourage walking and cycling wherever possible in accordance with the tests related to planning obligations. The scheme has been designed as a pedestrian and cyclist-friendly environment, and it will encourage walking through the street layout. It will also encourage walking through the extensive swathe of public open space, which provides a link to the village, to the recreation ground to the northeast, and the wider open countryside through a link proposed on Church Road to link with the public right-of-way travelling west into the wider open countryside beyond Warton. The scheme therefore creates pedestrian links to the existing community village and the wider parish. PMP3J, it makes a contribution to local identity and sense of place. Proposals should not feature generic designs and should set out how they take account of the locally distinctive character of the area in which they are to be located within any submitted design and access statement. So once again, this subparagraph, it's fundamentally for reserved matters. However, as noted above, the appeal development will marry the existing settlement edge through public open space with a standoff along the southern site edge with Warton Road, as well as reflecting the modern settlement hierarchy of the village and the growth of the village along the southern portion of Warton. Turning to PMP4, conserving and enhancing the landscape. Mr. Collinson identified conflict with PMP4 restricted to subparagraphs A, E, and F only. And again, Mr. Bullock and Mr. Cox have addressed these matters in writing and at the roundtable session, and a number of the above submissions apply equally to the analysis of this policy. So PMP 4A says maintaining and enhancing the landscape setting, landscape features, field and settlement pattern of the neighbourhood area. All of these considerations have been addressed above in respect to policy LP 14 and the earliest submissions on landscape character and urban morphology. PMP 4E, promote high quality residential design that respects local townscape and landscape character and reflects local vernacular building styles, layouts and materials. This wording essentially concerns reserved matters. The appeal development will plainly comply as a scheme of predominantly 2 stories with some 2.5-storey pepper potted like cornfields, and also set with an extensive landscape setting that retains and enhances the existing landscape fabric. I should say PMP 4F, other than in relation to the land to the east of Polesworth and Dorn, that's the H4 allocation, seek to minimise the encroachment of development into visually exposed landscapes, and where development is proposed on the edge of a village, it enhances views of the settlement edge from the surrounding countryside and does not lead to inappropriate incursion into the surrounding countryside by reason of its siting, design, materials, or use of landscaping. The proposal would not lead to any physical or visual coalescence, again as demonstrated by the LVA study and the accurate visual representations. The enclosure of the site by landform along its northern and western edge ensure that the appeal scheme will be contained and it would reinforce that scattered settlement pattern noted within the LCA 1 work. The LVA and the accurate visual representation demonstrate the scheme would have a limited and local effect and will be experienced largely from the existing village environment and not beyond from the open countryside outlying to Warton, and that's agreed with the LPA. Turning to the MPPF, at the roundtable session, Mr. Collins identified conflict with MPPF 187B and also with MPPF 135A, C, D, and F, and also MPPF 129D and MPPF 8C. And those are the only paragraphs relied on. These were also addressed by Mr. Bullock and Mr. Cox at the round table. There is considerable overlap with the above submissions on development plan compliance, but for completeness, the appellant considers there will be full compliance with all of these provisions. And there's also a continuing theme that a number of the design policies, referring there obviously to 135 and 129, a number of those design policies, they're fully capable of being addressed at the reserved matter stage. MPPF 187B, recognising the intrinsic character and beauty of the countryside. The appeal development would clearly accord with this MPPF paragraph. The appeal development has clearly recognised countryside and taken opportunities to contribute to the landscape through the reinstatement of some of the representative features on site, as recommended by the county and borough landscape character assessments. 135A will function well and add to the overall quality of the area, not just for the short term, but over the lifetime of the development. So this is the first of 4 subparagraphs of MPPF 135 relied upon by the council, and they fall within the MPPF's design chapter, and they're accordingly more the subject of reserved matters. As observed above, the council have agreed that the effect of the scheme would be localised and limited. The effect on the wider landscape character area is considered to be limited, and it diminishes rapidly with distance from the site. And the accurate visual representations demonstrate how well the scheme would integrate within its locality. And we say the scheme would not be an adjunct to the settlement pattern, and it wouldn't be incongruous through its nature due to that retention and enhancement of landscape fabric and new landscaping to reflect local character and species of planting. So the development would therefore plainly function well and add to the overall quality of the area over its full lifetime. I turn then to 135C, requires developments to be sympathetic to local character and history, including the surrounding built environment and landscape setting, while not preventing or discouraging appropriate innovation or change. The appeal development will be entirely sympathetic to local character and history. It will be of similar density, height, and nature as local development, creating a neighbourly scheme which is assimilated through landscape design, focusing on local plantings types and species. And the scheme will also be enclosed by Warton Road and Church Road and further by the landform. Again, it's not going to lead to coalescence in the host landscape character area at No Man's Heath to Warton Lowlands, which would remain as having a scattered pattern development in the wider open countryside beyond Warton. 135D and F establish or maintain a strong sense of place using the arrangement of street spaces, building types and materials to create attractive, welcoming, distinctive places to live, work and visit. And as set out for LP30 and PMP3, the national policy tests will be met through green infrastructure and public open space provision, walkable environment, and the collection of linkages to the village and the wider landscape. 129D, planning policy decisions should support development that makes efficient use of land, taking into account the availability of capacity of infrastructure services, both existing and proposed, as well as their potential for further improvement, and the scope to promote sustainable travel modes that limit future car use. MPPF 129D is related purely to efficient use of land and density. It is not a matter which can give rise to conflict in this case, and the overall development will be entirely consistent with its objectives and provisions. And finally, 8C, which is the environmental objective, the environmental pillar of sustainable development. The Council's reference to MPPF 8C and the environmental pillar adds nothing to the above MPPF and development plan references. The appeal proposal will accord with this element too. So in summary, on main issue 1, in summary, the appeal proposal's effect on the character and appearance of the area will be entirely appropriate and in accordance with both the development plan and with national policy. It will have an acceptable impact on the surrounding landscape, providing a good design and layout, and be spatially well integrated with the existing development in the wider village. This will be readily apparent from the plans and the overall scale of the site, as well as the LVA. In the context of the wider housing crisis, the Council cannot sensibly oppose development on open countryside and agricultural fields, which are not sensitive landscapes and which are well located with regard to access to the wider settlement. So I turn then to main issue 3, access to services and facilities, and the question whether future residents of the proposed development would have appropriate access to facilities and services. Warton has a good range of services in easily walkable or cyclable distance. There are also good existing public transport connections, which the Council's most recent settlement sustainability assessment has graded as frequent. Warton is a sustainable location in its own right. This was expressly recognised in each of the earlier 2019 decisions granting permission, which referred most notably to the school and the shop and post office and the bus service. The appeal proposals will improve the sustainability of Warton, both by increasing the bus services and through the pedestrian cycle route towards Polesworth with its range of services. And there's no other scheme or proposal which will bring forward those financial contributions. Mr. Parker's evidence has set out the specific services and the distances, including the journey times, on foot, by cycling, by bus, or by multimodal transport. I provided a reference there to his chapters 6 and 7, which sets out the tables. These were obviously explored in the roundtable session, and you'll note that the multimodal assessment was not contested by the Council. So looking then at pedestrian access to the village, there will be a shared pedestrian cycle facility provided along both sides of the access road, with cyclists joining Church Road carriageway adjacent to the Bellmouth, which will be traffic calmed as agreed with the LHA. And there will also be a pedestrian connection through to the recreation ground as well. So this access via Church Road provides the most direct route to the majority of services and facilities in Warton and an easily walkable distance to the primary school. The footway provision along Church Road on the southern side of the carriageway varies in width between 1.6 metres and 1.8 metres, but it meets inclusive mobility guidance, and it's typical of a rural village, and it's entirely safe to walk and to cross. So looking then at guidance on distances, Mr. Parker has set out the appropriate distances for walking, cycling and bus stops. Starting with walking, in terms of walking, all distances within the village will be under 10 minutes, including to the bus stops at the Maypole store. The CIHT guidance suggests up to 400 metres for town centres, 1,000 metres for commuting/schools, and 800 metres elsewhere. However, one needs to look at the broader guidance. So the CIHT planning for walking guidance states that about 80% of journeys shorter than 1 mile are made wholly on foot. A manual for streets also refers to 800 metres as a walkable neighbourhood, but it doesn't discount walking trips as being viable for up to 2 kilometres. And the 2024 National Travel Survey indicates that the average walk trip distance was 1,120 metres, and that 78% of trips under 1 mile were completed by foot. In terms of cycling, the CIHT planning for cycling document states that 80% of cycling trips are less than 5 miles and 40% less than 2 miles, but also that the majority of trips by all modes are short distances. So that's 67% less for less than 5 miles and 30% for less than 2 miles. So the potential switch to cycling is viable based on distance criteria. And the DfT cycling and walking investment strategy refers to that threshold of 5 miles or 8 kilometres. Again, the 2024 NTS shows average cycle trip distance was 5.3 kilometres. And then we turn to the LHA's, so this is Warwickshire County Council's own LC WIP, which refers to 5 kilometres and 10 kilometres distance for cycling. And the reference there is to figure NW17. And we'll note, of course, that the Borough Council were a consultee during the preparation of that LC WIP document. As to bus stops, whilst the distance of 400 metres is generally proposed for bus stops, the CIHT public transport guidance states that bus services should not be distorted to meet this criterion. The bus stops are just 625 metres from the centre of the site, which is an 8-minute walk. I refer to Mr. Parker's evidence on that 8-minute walk. He said it's entirely acceptable. So in summary, all of the facilities within Warton itself are within 800 metres. There are also a number of facilities within Polesworth within 2 kilometres, and most are within less than 2.5 kilometres. So the distances and the walk and the cycle times, they've all been tabulated within Mr. Parker's proof, which builds on the agreed list in the transport statement of common ground. And I'm not going to repeat them here, but the list shows retail, education, social and community, and wider services within a good, accessible range. And in terms of leisure and employment, all of these are readily accessible through public transport, including the extended bus service. So turning then to sustainable transport modes, I'm here thinking about MPPF 110, 115. Mr. Parker's evidence has therefore set out ample basis to conclude that the site is either sustainable in its own right, or it will be made sustainable by offering a genuine choice of transport modes in accordance with MPPF 110, 115. Turning to the pedestrian cycleway contribution, the contribution to the P12 proposed work is particularly important in this respect. This will significantly improve the experience of both pedestrians and cyclists by creating a safe route separate from the existing road and the associated traffic. And so this will promote connectivity between Warton and Polesworth in a manner that cannot otherwise be achieved without other funding. The bus services. The Council's own SSA 2025 recognised that the existing bus service was noted by the LPA as frequent. The proposed contribution will improve the service to connect through to Ventura Park, allowing it to become a frequent service to significant retail and employment opportunities from the morning through to the evening, Monday to Saturday. And as identified above, the bus stops are within an entirely appropriate 8-minute walk, allowing for that multimodal connectivity. And again, this cannot be achieved, this increase in bus service, it cannot be achieved without the appeal proposal. Finally, rail services. It is important to note that the site is also well located with regard to the national rail network. Tamworth Railway Station offers multiple services per hour across the region and connection to national destinations, again allowing for multimodal connectivity with rail. So then looking to the Curlew Close appeal, neither the pedestrian cycleway contribution nor the bus service improvements were present in the Curlew Close appeal, and accordingly these are also clear distinguishing factors explaining why a different conclusion can now be reached on sustainability. The appellant's improvements provide a genuine choice of sustainable transport ways directly in line with NPPF 110 and 115. A handful of additional Rule 6 matters. The Rule 6 party raised the question of primary healthcare and access, and also the secondary school bus. In terms of GP access, such trips are likely to be infrequent, taking an average of perhaps 6.27 visits per annum in 2024, and this does not generate a conflict with the wider NPPF policy or an overarching accessibility concern. As to the secondary school bus, this is still operating, it has not been removed, and there is currently no proposal to do so. So in summary, on main issue 3, in summary, the appeal proposal fully accords with NPPF 110 and 115 and with policy LP1 and LP2 as explored above. Future residents would have appropriate access to facilities and services. Main issue 4, agricultural land. The effect of the proposed development on the supply of agricultural land. The Council's case on agricultural land narrowed considerably through the proofs of evidence in the Statement of Common Ground and ultimately at the round table session as well. Land quality, current use and economic benefits. The grading of the land has been explained by Mr. Kernan, as set out in the topic-specific Statement of Common Ground. The 5.6 hectares of the site is BMV, being provisional grade 2, and thus over 60% likely to BMV, and is grade 2 split by some grade 3A. The land is primarily in arable use for cereals, i.e. for animal feed, and as Mr. Kernan has explained, this would theoretically yield a benefit of $1,200 per year over non-BMV land, on the basis of a benefit of just 6.7 tonnes of wheat. The Council have agreed there will be no harm to the wider farm business. As to the wider area, around 50% of the whole LPA area is BMV. So looking at 187 and 188, the Council accepted that the development would not be significant, sufficient to trigger NPPF at 865, and with this important threshold not crossed, the Council cannot allege anything other than limited harm. I should probably say anything higher than limited harm. Development plan conflict. The Council belatedly confirmed that development plan conflict arose only from LP1, not from LP16. Mr. Collinson was forced to accept in the round table that this was not due to any specific reference to agricultural land in the policy text, instead relying on the single limb, and emphasise, integrate appropriately with the natural ... environment. As the Court of Appeal observed in Chutley Campaign and Mole Valley, a conflict cannot be established with supporting text. The italics in that section below are in the original, but the underlining is added. I emphasise that the Court of Appeal there saying, I do not think the development that accorded with policies in the local plan could be said not to conform with the plan because it failed to satisfy an additional criterion referred to only in the supporting text. In the instant case, the Council have sought to read in a reference to best and most versatile agricultural land which does not appear in the text of policy LP1. However, even if that term natural environment is broad enough to encompass the loss of agricultural land, there will be no conflict overall with the policy. It is self-evident that the development which will give rise to limited harm in agricultural terms would integrate appropriately with the natural environment. And it's instructive that agricultural land has also not been raised as a basis for objection in respect of any recent applications around Warton. Mr. Collinson accepts that the issues of BMV loss cannot be attributed more than limited weight. Mr. Cox's evidence is that this should be weighed at the lowest levels, limited, and I should correct you, his rebuttal proof of evidence says that when he was using limited in his original proof, if you apply the Collinson scale, actually it's effectively negligible. So effectively, however you look at it, the appellant's position is it's right at the lower levels of harm and weight. But as set out in opening, there's a short answer to your main issue 4 question. The development proposal will not have a significant impact upon the supply of agricultural land. VMV is abundant across the council's administrative area. And so, in summary, the loss of agricultural land is not a factor that can be said to amount to significant demonstrable harm, either in its own right or collectively. A section then on other matters is specifically the Rule 6 party concerns. The Rule 6 party raised 3 concerns. The first 2 concerned perceptions of increased crime and antisocial behaviour and an overall loss of social cohesion. Neither of those are planning matters that can weigh against this development. The third issue concerned various highways matters, all of which were comprehensively dealt with by Mr. Parker, both in writing and at the roundtable session. So I start with perceptions of increased crime and antisocial behaviour. It's notable that the Rule 6 party phrases its objection carefully. The perception of increased crime and antisocial behaviour increasing in the village. Professor Phipps accepted correctly that the WRA do not and they cannot allege that the appeal development will give rise to any increased level of crime or antisocial behaviour. Warton has a relatively low level of crime as attested by the police statistics. I'm referring there to Mr. Cox's rebuttal proof Appendix D. The fact that there is a background level of crime in any settlement cannot be a basis for refusing permission for a new development. Social cohesion and new residents. The overall picture of Warton from the third-party evidence is of a healthy community with good levels of community organisation through various clubs and societies and with several community venues, the community hall, the social club, the public house and the recreation ground. There's even an annual carnival and other events at different times of the year. A new residential development of this kind is overwhelmingly more likely to increase the vitality of an existing community per NPPF paragraph 83. New residents will have expressly chosen to come to Warton, no doubt in part to take advantage of what it has to offer by way of community. And the appeal development is well located to ensure that residents can choose to participate in village life, whether by purchasing the shop, attending the village hall and the community buildings, or using the recreation ground. And the government's growth agenda means that many places must grow or continue to grow. The fact that development has already occurred in Warton is not a logical basis to refuse the appeal development and prevent the delivery of obvious benefits, not least the transport improvements, which will benefit the whole settlement. Highway safety matters. The Rule 6 party's concerns in respect of highways matters were addressed in the roundtable discussion by reference to the transport assessment work and Mr. Parker's rebuttal proof of evidence. The starting point in this case should be the fact that the Highways Authority have expressly confirmed that they have no objection and that there are no highway safety issues with the proposals. The local Highways Authority's view should be accorded great or considerable weight, and it will require compelling reasons for any departure in line with very well-established authority in this field. The Borough Council have also, quite properly, not raised any reason for refusal on highways grounds. Recreation ground parking. Mr. Parker addressed this in evidence. Additional parking in this location occurs once a week on Sunday, when the traffic flows across the network are much lower. The photographic evidence suggests that the parking extends up to the site access junction, but not beyond. And this would have a limited impact given the forecast traffic movements to and from the site, primarily to and from west of the access. So there is therefore no highway safety issue, especially given that there have been no injury accidents in the latest 5-year period along Church Road, and it will be traffic calmed with the development in place. Traffic volumes, congestion and safety. These matters were also dealt with extensively by Mr. Parker's written and oral evidence by reference to the transport assessment. There is no current congestion issue. The junction capacity analysis demonstrates there were no issues in future years with background traffic growth, taking into account all committed development and the proposed development site traffic. The LHA have agreed, and there will therefore be negligible queues and delays, and the surrounding roads will operate within capacity. As to safety, the latest 5 years of data show no issues and no worsening pattern either. The Linden Lane Junction is subject to an LHA safety scheme. but that will be delivered in due course. And the access has been subject to independent road safety audit, including amendments in line with the designer's response, has been reviewed and accepted by the LHA safety team. So I turn then to the conclusion, section 38.6 and the planning balance. The development plan and the presumption in favour of sustainable development. In conclusion, the appeal proposal would accord with the development plan considered as a whole. Specifically, it would accord with all of the policies named in the putative reasons for refusal. And I note my earlier reference referred above when I introduced this to LP16. It's been agreed, obviously, by the council LP16 no longer in play. So it's effectively LP1, LP2, LP14, LP30, as well as PMP3 and PMP4. And we say, the appellant says, we accord with all of those policies. But this is also a case where the presumption in favour of sustainable development applies, and it clearly directs towards the grant of permission. And that's a powerful material consideration. We echo the written ministerial statement's words accompanying the NPPF, and they made clear the presumption in favour of sustainable development must have real teeth. Government's intention is that the presumption carries real weight, acting as a significant adjustment to the decision-making balance in favour of approving development. So turning to the benefits and housing generally, the provision of the housing to meet part of the council's major shortfall should be accorded substantial positive weight. The council's arguments seeking to reduce the weight to merely significant do not stand up to any scrutiny. The council have now submitted the case of Hallam Land in an apparent attempt to rely on 51, and that is the quote in my learned friend's submission. But let's look at the wording. It says that the weight given to the benefits of new housing development, where there's a shortfall, is likely to depend on factors such as the broad magnitude of the shortfall, how long it is likely to persist, what the local planning authority is doing to reduce it, and how much of it the development will meet. And on each of these factors, the council's case is extremely weak. The magnitude of the shortfall is massive. 4,306 dwellings, leaving just 0.82 years of supply once the clear evidence test is properly applied. That shortfall will persist for some considerable time, as the council have no new local plan realistically on the horizon to replace the stalled allocations. The council are, with respect, unable or incapable of doing much to significantly reduce the shortfall. The council made the submission noting that the contribution of 110 homes would make a trivial contribution to supply. That is not how officers would professionally describe the position, and it's very notably at odds with government policy. There is, realistically, no other option to meet the shortfall than to grant more applications on unallocated sites. In this context, a development of 110 homes will make a sizable contribution, and it should be given the highest grading of weight applied on the 5-point scale. That's substantial. Affordable housing. The affordable housing benefits should also be accorded substantial weight. As identified in opening, there is a steadily widening gap, as the council has serially underdelivered between 2019 to 2020 and 23-24. Against that 133 dwellings per annum target in the HEDNA, just 256 units have been delivered, generating a shortfall of 419 units at the end of 2023 and 24. And in the last 2 years recorded, 2022 and 2023 and 2023 and 2024, the council completed just 32 and 17 units respectively. So that should be respectively, not respectfully. The delivery of 44 new homes at a single site is therefore clearly a marked improvement, and it's not a matter that can be dismissed or reduced in weight on the basis of unsubstantiated concerns about take-up by registered providers. Economic benefits. The economic benefits arising from the appeal proposal should be accorded moderate weight. The government is committed to a strong house building sector, ensuring training, apprenticeships, and overall continuity of employment. As one of the few sites in the borough capable of making a rapid start, the appeal site is well placed to accord with this national policy objective. And the additional resident expenditure on local services in line with NPPF 83 will also promote those services and local employment. Transport benefits. The transport benefits are notable. The appellant accepts that whilst these are necessary to secure development plan compliance, there will still be wider benefits to the village as a whole, and these are important in their own right. In short, this provides a contribution to the very scheme that the LHA itself wishes to promote. Accordingly, the transport benefits should be accorded moderate weight. And the appellant has attributed limited weight to on-site biodiversity. So let's look at the cumulative weight to benefits. The council's evidence sought to average out, this is Mr. Collinson's proof, it sought to average out the benefits to achieve a lower overall grading of moderate. That was quite plainly skewed and illogical. The correct position is that one takes the substantial benefits in respect of market and affordable housing and adds the economic and transport benefits. One does not carry out an averaging exercise to reduce them. The consequences of not proceeding with the scheme, and at this juncture I think it's important to provide a direct answer to your post-CMC note, paragraph 10, where you asked about the implications of not proceeding with the scheme. We said they're principally twofold. First, the housing benefits would not be realised, specifically the opportunity to provide 110 homes, including 44 affordable homes within the 5-year period. Second, the transport benefits would also not come forward, specifically A, the additional bus services and the significant contribution to pedestrian cycleway improvements, P12. Just in respect of 1117, when the conditions are provided to you, obviously that will specify the timescales for submission of those, submission of reserve, the initial phase, and obviously the reserve matters. And Mr. Cox can attest to that. So we say simply, looking at those housing benefits, the transport benefits, and that transport, this will be a significant missed opportunity in its own right if the scheme doesn't come forward. Harms and adverse effects. The appellant has explained its position under the main issues above in respect to both questions of development plan conflict and the overall level of harm. The harms of the development would all be very much at the lower end, capable of being accorded no more than limited weight. Mr. Cox has carefully listed these. Landscape harm arising from the development of a single agricultural field in what is not a sensitive landscape, limited weight. Loss of agricultural land in a context where the development is not significant and the field has very little economic value, attracting limited or negligible weight. And finally, if conflict was to be identified with LP2, limited weight in that respect. These harms are nowhere near capable of significantly demonstrably outweighing the substantial benefits. Mr. Collinson properly accepted that even, this is at the end of his cross-examination, that even significant adverse effects of the kind enumerated in his proof could not significantly and demonstrably outweigh significant benefits. That's if he corrects his moderate to significant. And so once it's correctly accepted that the benefits are substantial, the council's opposition is untenable. So in summary, this development is an excellent example of exactly the form of development which the government wants. It's capable of delivering substantial benefits rapidly, well within the 5 years. And so for all these reasons, we request that the appeal be allowed and permission granted. And so I turn then to my responses to initially the Rule 6 parties closing submissions. And I emphasise above, this isn't intended to be exhaustive. And if I haven't referred to anything, that obviously doesn't indicate any agreement or acceptance with the rest of those closings. So if you take up the Rule 6 parties closings to start off with, paragraphs 2 to 5, they refer to this concept of proportionality. We say, and I've set out earlier on, that proportionality for the purposes of LP2 must be assessed by reference to the current settlement population with projected increases from existing consents. It's not correct to interpret LP2 by reference to a historic baseline, including in 2016. I think that applies to both the Rule 6 and the Council's submissions to that effect. 8 to 9. This is a reference to loss of services. The level of services has remained largely consistent, notwithstanding the loss of the pubs. And Mr. Collinson has accepted that the increased expenditure from new residents will be economically positive for existing services, including the pub. And that's also true for the shop and the post office and the community facilities generally. 8 and 11, there is a reference to the bus service not scaling up. We say very simply, the appeal proposal is increasing bus services. 10, it is said in the second sentence that Warton sits at the far edge of the borough. Warton is not at the far edge of the borough. It's actually closer to Polesworth than a number of other settlements, and the appeal site, of course, is within the 2-kilometre range, as we've explored already under main issue 3 above. 12. Professor Phipps says, I fully support the provision of social and affordable housing. We say it's positive to hear support for affordable housing, but the central difficulty is that the council is granting permission for far too little of it, such that completions are very low. And so the only way to deliver more is to grant permission in locations such as the appeal site, and that's entirely in accordance with the development plan's affordable housing policy. 15. A reference to newcomers. As Professor Phipps noted, both by reference to his own experience and by reference to the volunteers from new development, he spoke positively of a number of residents from the new developments. Newcomers are vital for this settlement, and we say that Warton is well placed to integrate the residents to the appeal site, and the appeal site itself, it's well located to allow them to walk to the main services in the village. Of course, that social cohesion will take place. And I say I haven't addressed everything in the statement. Obviously, a lot of it has been addressed through earlier paragraphs. So the council's submissions. Let's just go to paragraph 4 of my letter friend submissions. The council say several times they've got a significant housing shortfall. Well, a housing shortfall at 0.82 years, it's not merely significant, it is severe. Paragraph 7, a reference is made to the inspector who looked at the local plan. Considering the local plan could not likely favour the hierarchy. The report itself, it did not specify what a commensurate level, type and quality of day-to-day provision would be. We'll come on to that. We've already addressed that earlier on, but we'll come on to that again. 9, a reference is made to the loss of the public house at the Fox and Dogs. Again, it's similar to the points I raised above in response to the Rule 6 party submission. The loss of the Fox and Dogs actually directs to the benefit of having further residents, in line with Mr. Collinson's acceptance that increased expenditure and more custom will be positive for the pub, as well as the shop and the post office. 13 and through to 15 references to Mr. Collins' evidence on landscape and visual effects. The simple point here is that the council have not explained their reason for disagreeing with any of the specific landscape and visual effects. An absence of qualification or a misconceived reference to landscape and visual assessment as pseudoscience does not absolve the council of a requirement to explain why a different view has been reached. 24. The development will not be heavily reliant on the private car. It's in a location that will allow for walking, cycling into the centre of the village, and the improvements in public transport, both the bus services and the pedestrian cycleway, they clearly will provide a genuine choice with respect to the sustainable transport modes. 28. It is said that Mr. Cox accepted in cross-examination that the appellant did not have a reason per se. Rather, it was simply that they were inviting you to reach an inclusion of this issue to your colleague. Now, we say that that's not a correct recollection or record of Mr. Cox's evidence. He explained, you'll have your note on this, he explained very simply that his view, as a planner of considerable experience, is that the village's services allow on. He talks about the resident. They allow you to buy goods, post letters, do your banking at the post office. You can educate one child at the primary school or the nursery, socialise and meet in the community facilities amongst other activities. So we say the appellant has fully explained why it considers that a different view should be reached. Paragraph 30, by reference to written representations, the point we're making, it's not about the written representation nature of the decision, but it's simply that DL8 of that decision does not explain what services and facilities were actually considered, and therefore why these were considered to be limited or insufficient for day-to-day provision. We say in the circumstances, it's therefore entirely open for a different view to be reached from the brief conclusions given. It's not only entirely open, we say, as I said, 28, but there's clear evidence to say that the day-to-day provision is entirely appropriate and commensurate for this development. 33. It is held against the development proposal that it will not provide any additional services and facilities within Warton itself. It's not a requirement of LP2 that residential development should increase services. The appeal development is making important contributions to the existing services, notably the school, and it is making important contributions in respect to transport. It will support and enhance the other existing services as noted above and as agreed by Mr. Collinson. 39. There is criticism of the fact that there'll be a grassy route through the recreation ground. The connection to the recreation ground allows for connection to a communal and public space, and it ensures integration with the village. And in any event, Church Road it provides a good pedestrian access. And I echo that 43, where the council said, well, even if it's considered there is a direct and legible route into Warton, and we say that Church Road is plainly a direct and legible route. Now, 46, helpfully, we get a sort of screen capture or a quote from the Planning for Walking document. And this is a reference to C10.7 in the core documents. That's a landscape document, and this has been extracted from it. We just make a few notes here. The specific reference here you can see from the title is to traditional compact town layouts. Now, as MPPF 110 notes, a different approach can be taken between urban and rural locations. And if you read beyond that reference to traditional compact town layouts, and you go to the right column alongside it, that text expressly says, in general, the requirements are to separate pedestrians from vehicle traffic and to limit vehicle speed. Separation can be in space by providing separate areas for pedestrians and vehicles. And so we say, when you look at the text as a whole, this is exactly what the new route is going to provide. So effectively, the council's criticism of the local highways authority's proposed P12, it makes little sense. The council, they will be directly involved in the LC Whip document, and the LHA plainly have relevant expertise. The route's safe, especially with the separation of the pedestrian cycleway, and there's no expectation that every part of the route must have surveillance. 49. Reference to distance of the bus stops. The LHA expressly recommended that the bus stop was well located, and we quote there, in this case, the raw location of the highway authority. Given the raw location, the authority will accept the use of the existing bus stops. And 400 metres is not a ceiling or a cut-off, and the distance is not considerably in excess of that. We say at 625 metres, we've quoted that above. 61. At the 0.1 supply point, the council's attempt to present 110 homes, including 44 affordable homes, as insignificant, that's the words used there, That's radically out of step with the NPPF, the WMS, and all government statements. But put another way, 110 would boost the extremely low existing figure. We've identified that at only 8 or 8 dwellings. 62 then, the council are effectively shying away from the difficulties in the light of their comments addressed above, if they genuinely think that schemes of 110 homes are insignificant. 66, I think there is some disagreement here as to what exactly was conceded in the planning evidence. There was obviously a round table session in which we very clearly set out our position on LP14 and PMP4, and we set it out in closing above. We say that Mr. Cox did not accept conflict with LP14. He said he did in the round table session where he seems to explain the absence of conflict. 69, there's some reference there to MPPF 187. We say, if you look at the MPPF, it clearly does not require conflict with MPPF 187 in all cases where there's any landscape harm. So we say, as MPPF 187 exemplifies, an overall approach must be taken. And then finally, 71. Again, that's the conclusion that we accept conflict with LP14. As in, for the reasons I said earlier on, we don't accept there's conflict with LP14. 75, as a freestanding reference, we accept conflict with PMP4. About it again, we don't accept conflict with PMP4 either for the reasons I've said above. So I think those are our submissions on that. I just checked with Mr. Cox at this point about delivery timescales. If Mr. Cox could come on screen, because I'm conscious that you haven't seen the completed conditions.
No, I've had email, but obviously I had a chance to open them.
If Mr. Cox could just confirm the point on timescales for delivery, and that would then conclude my submissions.
I can do. In terms of the conditions, they agree with the council, and they have been submitted. In respect of the submission of reserved matters, it's been reduced from 3 years to 2 years.
Okay. So if I can assist you any further on any issues, just check I'm not receiving any WhatsApps or similar from my team, and I haven't. Those are our closing submissions, and as I said, to be read obviously alongside our pre-evidence and rebuttal evidence, and of course the statements of common ground. So no further submissions from the appellant.
Thank you, Mr. Corbett-Fletcher. Can I just check if any of the parties want to make a submission of costs?
So just the instructions on this. No, sorry, I have no to costs.
Right. Okay. In that case, then I'll just check if any party wants to bring any final things to my attention.
Just to thank you, sir.
Thank you.
Thank you very much, sir.
Okay. Okay. Yes. I mean, can I thank the council for logistics arrangements today, which worked out very well in spite of my cynical foreboding about it. So many thanks to the council and also for hosting the event last week. And can I thank local residents for their participation as well as the 3 main parties. So yeah, thank you. I wish you the best of the season, and can I thank you all for your participation. And I will see at least 3 of you tomorrow on the site visit. And no, it's a good forecast. But can I thank you all? And I hereby close the inquiry. So thank you.
Thank you, sir.
Yes, sir.
Thank you, sir.